Yes, my lord.
Yes.
as prescribed by the council,
INC.
INC.
Subsequently, it was shifted to November.
All right, November.
Yes.
And then,
But the state government, our council has extended it up to December, which they should not have done. December 30th. When this was come to the knowledge of the council, by that time they have already fixed the dates and everything for the admission.
so we are clear on this.
Yes.
And that is the only thing which we wanted to know. Whether that date, initially September 2023, subsequently November 2023. So I have not been able to find out that document by which the September date was extended to 11 November. So do you have any document?
That was the communication given by INC to.
Is that on record?
Yes, sir.
There was no
Irregular.
no, only this was there.
You can do it tomorrow.
Yes, my
Nothing
lord. I will
happened.
do it.
Find out.
In the first
Yes.
brief, I remember all of that is there. We will point it out.
Tomorrow.
I will get it.
So that is the only
Yes.
clarification which we.
Yes, ma'am.
There was a
Required.
particular document by INC which clearly stated that after this date, all the admissions will be irregular, and it was communicated also. So that document is there on record. We'll just give it.
Please.
tomorrow.
I'll give tomorrow. I'll give it.
And the other thing is that just we intend to direct all the authorities to strictly adhere to the timeline.
Yes, ma'am.
Which the state government has prescribed for the purpose of grant of recognition. So that you will have to strictly follow, and you cannot deviate without the leave of this court.
Yes, ma'am.
This is one thing. So that is up to the stage of grant of NOC and affiliation, whatever.
Yes, ma'am.
What about the admissions?
Admission, my lord, after the NOC is given, then there is for admission, we got counseling for the
Not
institutions.
counseling.
Institutions
All right,
who has got NOC,
we will-
my lord.
We will see.
And that also would require, because your lordships, this is
No,
precisely
that is to be fixed by the INC.
INC.
So we will not fix
Yes,
that.
Yes.
Yes.
So whatever is fixed by INC, they should just adhere to that.
And so far the recognition aspect is concerned, they themselves have
Yes.
fixed the
Yes.
time schedule. So that they'll have to adhere to.
Because this
always.
year, the thing is that the entire year went by and the admissions, the admission procedures did not even start, which basically the exams and the counseling. So the issue lies there.
All right. Now after the case,
Test admission item number 2.
Yesterday matter, that's 60-30.
yes.
The counter at flag X, which was not before lordship, but lordship have gone through that counter. The recommendation has been made to 30, but they have made it to 60. That is remember that. May I recapitulate lordship memory? May I recapitulate lordship memory?
No, we remember.
Yes.
Which course is this? PDIS?
PGP, Post Diploma Industrial Safety, PDJS. Course, PDIS course, Post Diploma Industrial Safety course.
And what is your submission on the last date for admission?
My lord, inquiry was made.
No,
Last date,
last date has been fixed, 30th of April.
My lord, that I have stated before, my lords, that if my lords will consider it, then my lords, all these technicalities will not stand. My lord,
And
we
the
will not take
admission-
those.
Admissions are to be given from which? Is there any list? Is there any selection?
Counseling agent.
Actually, my
How-
lord, they are open till June, till May
But
and
they have
June.
already made the counseling, that is up to the June. They can give appointment, right? They can
The-
give admission.
Admission. Their school institute's name don't find place in the portal.
That is right,
That is the reason.
that is the problem.
If my lords are considering interim direction,
No, we will decide.
Well, what I suggest you also can dispose it of. So far 30 seat is concerned, I think my Lord President agreed that there is no
No,
dispute.
we are of the view that there is no basis
ma'am.
appearing from the records. Why you decided to stop the entire admission in the institution. And the reason which has been assigned is apparently non-speaking and without any basis referred in there. This is what
That's the Lord.
we,
Well, so far the rest of 30 is concerned, if you'll also be look to page 68 on 12/4/2024, we have complied with all the deficiency and we have reported to them, let them make an inquiry, let them take appropriate action. Because after their inquiry, they have made some deficiency that we have already removed and we have already reported to them on 12/4/2024 under Annex 9 series. Let them take decision after inquiry. Yes.
tomorrow for order. then.
Hello.
That- Do what was required to be done by the committee.
Right, sir.
So we'll direct them to do that, even for those 30 seats. That is a report.
On the basis
They
of
were
the report,
required to
yes.
take a decision. So that decision we are not satisfied with. But
The whole
still,
difficulty is if this year will be now lapsed because of.
no, we'll give a
Ah, yes.
timeline.
Your Lord Speaker,
We'll give a time, we'll give.
then why not your Lord Speaker say also for the 60 seat rest, 30
For
seats.
66, they can consider
Yes,
the
consider
whatever.
they can make
But so
inspection.
far
of
as
30
30,
That's-
we will set aside that decision and we'll ask them to pass an order, take a fresh decision. In 7 days, within 7 days.
I think my learned friend will suggest them that because of the, except the inspection is very clear. Let them take it. As your lordship.
See, his advice,
Yes.
his advice. So,
Yes.
and the decision will have to be taken by them, the authorities. Day after tomorrow, heard? Was this matter for judgment on? Day after tomorrow is Thursday. Or Monday it can come. Monday we will have enough time. Monday.
Lordship will pass orders on Monday.
Yes, judgment. It will come for judgment on Monday.
Item number 3.
Item number 3. This is the some inadvertent type that could have been there. Otherwise, minors have already confirmed the relay and it is to be heard. It should come for admission. This it has come because this type order number 5. Madam, can you see the notice? That is to be removed. Order number 5. No. In order dated 26/4/24, order number 5 is inadvertently typed out as order number 3. Order after order number 5, there is order number 6. Order number 3. Order dated 26/4/24. It is typed as order number 3, it should be order number 5. That the order dated. Why is order number? Why is that? That should be order number 6.
No, that is order number 5. Because you see, the order dated 14/3/2023.
Hmm.
That is order number 4.
Hmm.
After 4, that 6 is something though, and that is another case, WA 137. That has been, I think that batch matter. So this is not related to this case. That order number 6 as it shows. So this 3.
856.
5-1.
The order dated, number of the order dated, date,
26.
number of the order dated 26/4/2023 and 24 be treated as order number 5 in place of order number 3, which has been wrongly typed in this said order. Yes.
It is under press admission.
It has come for admission. No?
Press admission.
Come for admission. Huh?
This has come under fresh admission. Admission, yes. That is only typographical.
Is not in order, man. It's on press admission.
It is for admission.
Yes.
As requested on behalf of the appellant, list this matter on after revocation.
Item 4.
This is a consolidation matter where if your lordship looks at the impugned order, page 12, the Honorable Court has, single judge has directed that since the factual aspect is there, is not going to interfere. But I don't want to challenge the order as such on merit. I just want that liberty should be granted to approach the appropriate authority, the Commissioner of Consolidation. So that liberty may be granted only. Well, the factual aspect, obviously the court will not interfere.
An order dated 3/1/2023 passed in WPC number 26613 of 2017 is under challenge in the present intra-court appeal. London single judge has dismissed the writ petition by the impugned order on the ground that the case involved
Page
disputed
15,
question of
paragraph 4.
facts.
Page 15, paragraph 4, Marat. Huh. The only commissioner can do, nobody else.
Consultation operation of that particular village.
Correct.
Therefore, this fact cannot be after closure of the consultation.
No, after closure, the commissioner retains the power. After closure,
They are subject to limitation.
limitation for 37. There is no limitation in 37. Paragraph 4, it is mentioned difficult to enter into conflict involved in.
Mentioned in paragraph 4.
Paragraph 4, Marat. This court finds difficulty to enter into conflicts involved, the factual conflicts.
Para 3 is also important. Para
Yes, paragraph 3 and 4 both.
3 is
Distribution of chocker is there prior to the filing of the writ petition.
But in the said writ petition, what was challenged? What was under challenge?
So if the challenge that subsequent event has taken place, therefore the court should intervene in the matter. But the court says that's a factual dispute is there. So I'm not going to interfere into that. So the commissioner
that word
consolidates the
factual is
appropriate
missing.
authority.
Dismiss the writ petition as in view of closer notification
Yes,
under section 41.
under section 41 of the Act.
41 of the Odisha Consolidation and Prevention of Fragmentation Act.
Yes,
Prevention of fragmentation of
Act what?
1970.
1972.
72.
Stop. Then senior counsel appearing on behalf of the appellant has submitted that though the impugned order cannot be said to be suffering from any legal infirmity requiring this court's interference in the present intra-court appeal, the court may modify the said order granting liberty to the appellant to approach appropriate forum for the appropriate statutory forum
Right.
for the relief which was sought in the writ application.
Right.
Stop. This writ application, writ appeal is accordingly disposed of with the liberty to the appellant to approach appropriate forum in accordance with law, if permissible, subject to law of limitation.
Right.
Item number 5.
Like my lord, yesterday it was listed. It was hard for some times. Now I want to research something, my lord, because the appointment was not challenged earlier. appointment of managing committee, my lord, is not challenged. Now, my lord, in the State Council, my lord, raised a point regarding the appointment. But fact remains that I have, the petty appellant has knocked the door of the justice whenever the similar situated person was given the benefit. Chaturbhuja Patra was given the benefit. The crux of the case is he was appointed in the year 1988 and the present appellant was appointed on 27/9/90. Though 89 Act came into force, the Honorable Single Judge denied the relief. Fact that my point is that though rule came into force in the year 92, so there was no selection committee. Therefore, I should have been considered as like a Chaturbhuja Patra. That was my
That judgment will have no application.
because my rule came into force in the 92. In fact, my lord,
Still some rule was required to be followed and some rule was there.
yes. So, my lord, therefore, I want to, my lord, make research of the body. Therefore, I seek adjournment.
Research what?
But regarding this, that
What
earlier
research?
rule, that earlier rule, my lord, my impression was, your lordship, so
Impression?
though Chaturbhuja Patra was appointed in the year 1988 and benefit was given to him, so the same benefit should have been extended to me.
The decisions cannot be taken on the basis of your
Your lordship may
perception.
take this matter in any other day next week, so that I
Fine.
will apply to your lordships in a good manner.
Tomorrow.
Tomorrow, my lord, I have said, but next week, my lord, 15th, your lordship.
All as requested on behalf of the app. This matter on 15th.
Item number 6.
Yesterday the file was misplaced, so I made a mention. No, here, the vision is controlled and notice has been issued. So, ma'am, we fix a date, here the matter.
No notices and issued, someone is appearing.
Nobody has appeared. Madam, relay has been called on the main week, the notice has to be.
Notice, let go. Let us see merit. Don't know. Item number 6. Let us see why notice should go.
No, order dated 16/8/23 on annex to 1 at page 11. Before my lords, look at this order. The only thing that is to be considered is the condition that a person is required to be registered with the employment exchange. This honorable court has said that no, even if he has not been registered, on that ground you cannot.
Absolutely correct. This is the law.
That is the case.
His lordship was followed our own,
And 3 decisions
our own
has been followed.
High Court decision went up to Supreme Court. Honorable Supreme Court reported case.
The state of Orissa has preferred present intra court appeal putting to challenge and order dated 16/8/2023 passed in WPC number 16912 of 2023. So stop. Next, whereby the learned single judge has disposed of the writ petition with a writ petition, taking into account the Supreme Court's decision in case of Union of India and others versus Ms. Niti Lata Nanda, reported in 2010, Volume 2, OLR SC 636. And this court's decision in Asis Kumar Gatia.
No.
Gadtia.
Gadtia versus State of Odisha dated 17/5/2023. Passed in WPC number 11623 of 2023. So stop. With a comma, with a direction to the state to include the petition, include the name of the respondent in the select list for appointment. Which post? For
Constable.
appointment to the post of constable and issue appointment order. First off, next. The facts of the case are not in dispute. First off, pursuant to an advertisement for the post of constables, bracketed civil, in Odisha Police, the respondent had applied. He was declared successful in the written test as well as the physical test. So stop. In the final select list, however, his name did not appear, which made the respondent approach this court by filing the aforesaid writ application. So stop. In the counter affidavit filed on behalf of the appellant, a plea was taken that the employment registration certificate, what is this?
Employment registration in employment exchange. not free.
Employment
This is the-
registration certificate of the respondent issued by the employment exchange
Was not renewed.
was
Not renewed.
not renewed.
No.
Not renewed on the date of verification.
In the days of advertising.
No. Was invalid, sir. Was invalid. The same having not been renewed, comma, on the date of application,
In the date of advertising.
on the date of advertisement. So stop. One of the conditions in the advertisement inviting applications was that the employment registration certificate must be valid on the date of verification. Full stop. Next. When single judge, after having taken into account the Supreme Court's decision in case of Pritilata, bracketed Supra, and Asis Kumar Gadatia, bracketed Supra, has concluded in the impugned order that non-registration or failure to renew the employment exchange certificate cannot stand as a bar to consider the petitioner's case for appointment. Respondent's case for appointment. So stop. Next. When counsel appeared, when AG appearing on behalf of the appellant has attempted to convince this court that since it was specifically mentioned in the advertisement that a candidate must possess valid employment registration certificate, comma, the authorities rightly rejected the petitioner's candidature for selection and appointment as constable. Stop. Next, after having perused the impugned order passed by the learned single judge, we are of the considered view that the same does not suffer from any legal infirmity, and based on the decision rendered by the Supreme Court in case of Preeti Lal Nanda. Stop. The impugned order does not suffer, the impugned order does not require interference in the present intra-court appeal. Stop. This appeal is accordingly dismissed.
Item number 7.
No, 7, kindly may be taken up next to you. Next to you.
Aye,
Mr. Das is busy in another court.
as requested.
Item 8.
Yeah.
Okay.
Item number 8, my lord. Petitioner has challenged the order.
My lord, item number 8, my lord, and for the respondent number 5. My lord, a copy of the writ appeal be served upon me. I am submitting on behalf of Ms. Mahapatra, who has appeared in as respondent number 5. And it, my lord, may I pray the case may be kept to day after tomorrow for final decision.
I have no objection over the date of the hearing has been fixed to tomorrow. Therefore, if you,
Which hearing?
in view of the order passed by the honorable single judge, the yes. If my learned friend is requesting for day after tomorrow, I have no objection. But the date has been fixed tomorrow.
So let us see what is the order. What is wrong with the order?
Yes, ma'am. Your lordship, I am reading the relevant portion. Para 4, para 3, the learned counsel for the petitioner submits that there has been an interim arrangement to look
This is
after.
item number 820.
Pardon?
Is this 820?
Yes, ma'am. Yes.
So you are hearing, you are reading paragraph 3.
3 years.
Is read.
Mr. Ms. Mahapatra, learned counsel for petitioner submits that there has been an interim arrangement to look after the management of the organization, namely Lutherana Mahila Samiti, but the proceeding was disposed of on the premises that the authority concerned, namely OP number 3, is having no jurisdiction for approval of its managing committee and matters connected therewith. It is further submitted that the response of the state from the counter affidavit filed through OP number 3 reveals that the OP number 3 instead have the jurisdiction to consider the same, he being the additional registrar of the society. The objection of Mr. Biswal, learned counsel for intervener, is noted down. Noted down, there is no note down of our objection. Since the proceeding, para 5, Miss case number 01-2022 was disposed of with an order under Annexure 10 with a decision that the OP number 3 lacked the jurisdiction for approval of the managing committee
of the petitioner, which has been clarified by the state in its counter. Subject matter is in dispute needs afresh adjudication by OP number 3. In other words, since opposite party number 3 being the additional registrar of society, in view of the reply of the state with counter affidavit on record that he has a jurisdiction instead, the court is of the conclusion that it should be looked into with an order of on merit with the participation of both sides as the same would serve the purpose and meet the ends of justice. Hence, it is order. In the result, the writ petition stands allowed. Consequently, the impugned order 12 July 2023 under Annexure 9 its 10 hour is set aside to the extent as aforesaid without disturbing the interim management of
So
the
what is
society.
wrong?
My lord, the ADM, the respondent 3 has no jurisdiction. Because
Who is responsible?
your lordship kindly,
Just a minute. Who is responsible?
respondent 3 is the ADM cum additional registrar of society. He himself stated in the counter that there is no such provision for giving any approval of the society. He himself in the same counter. Your lordship kindly turn to page 85 of the counter. The counter filed by the ADM.
So according to you, ADM does not have additional registrar, does not have the jurisdiction.
Jurisdiction.
How do you say this?
Your
Yes,
lordship
Congress.
turn to 85. The additional ADM himself noted down that I have no jurisdiction.
We are not bound by that statement. Whether he has jurisdiction or not will depend on statutory provision.
Yes,
Where-
he noted that there is no such provision. He noted that there is no
You
such
tell us whether there is any provision or
that
not.
additional register, he tell us. Page 85, paragraph 12, my lord. Paragraph 12.
Society's registration.
Yes. Who you are
It
feeling?
is a
Yes, my lord. And para 12 it is written, but
also in 13 years.
that neither party have prayed for approval of the
Yes.
body, as there is no provision under the Society Restriction Act for approval of any changes made in respect of their common law.
Yes.
As they are well aware of the provisions, they have submitted the documents for information only. So only that approval part, he has said that there is no provision under the act that the additional register.
Where is the provision? Where is the power?
Section 4.
What is the statutory provision?
Study section 4. Section 4. Section 4 of the Society Registration Act, man.
Yes.
That section 4, annual list of managing body to be filed. Society Registration Act. Once in every year, on or before 14th day of succeeding the day on which, according to the rules of society, the annual general meeting of the society is held, or if the rules do not provide for an annual general meeting in the month of January, a list shall be filed with the registrar of joint stock companies of the names, addresses, occupations of the government, council, director, committee or other governing body then entrusted to the management of the affairs of the society. Then in our state, that is section 4A, just below. Changes in the list mentioned in the section 4 and rules to be filed. Without prejudice the provision of section 4, any change in the personnel on the list filed under the said section occurring during the year to which such list relates shall be intimated to the registrar of society within 2 months of making such changes. A copy of every alteration made in the rules and regulation of the society, certified to be a correct copy by not less than 3 of the governors, directors, or members of the governing body, as the case may be, shall be sent to the registrar, or member of the governing body, as the case may be, shall be sent to the register of a society within 2 months of such alteration. There is no such. It is for information. This section 4 and 4A. Therefore, the respondent 3 in paragraph 11 and paragraph 12 and 13 written that there is no such provision for approval of change of the.
And where is the approval of the body?
Approval of the body.
The body itself will approve and they will intimate it to the registering officer. That is the section 4 purport of the section 4. And the governing general, in the general body, the governing body will be selected and that will be approved and it will be intimated to the.
No, where is this expression approved?
Section 4. Section 4 is that it will be intimated. That is why the ATM has, the additional register has shown affidavit that it is for the information of the.
May I draw your kind attention? Page the annexure 10 of the writ petition.
Where is the provision?
Provision? There is no such.
You are appearing.
Paging for the respondent or 5.
There is two
And you
dispute between two groups. They
on
are
behalf of Ms. Mahapatra, Lordship, I mentioned it may be taken up day after 2. Lordship, it may be finally disposed of.
As requested on behalf of the parties, list this matter on. Sanjay, first 5 cases.
Item
9.
Tomorrow is the date, therefore.
No,
Item 9.
he can take this decision that he cannot,
Yes,
he
sir.
does not have jurisdiction.
Lordship, item 9, 10, 11, 12, I'm being led by senior advocate Mrs. Pami Roth, Your Lordship. She's on her legs in another court, Your Lordship.
You are here.
I'm seeking a small password, Your Lordship.
Why you are here? Start.
No, Your Lordship, it's a case which has
Sorry.
repercussions all over Odisha, Your Lordship.
Huh?
Well, these are matters, with due respect, my lord, may be permitted to submit. Matters regarding this day and night medical shops. But the writ application has been dismissed, as a result of which, throughout Odisha, for more than 100 shop owners, actually, they are going to be suffered, in fact. The medicine, all life-saving medicine, drugs, everything is there.
What I
What I'm saying, number of writ appeals are filed, same subject matter.
Same judgment also.
If Lordship can take up for tomorrow, my matter has not been listed today, and I think Mr. Rautray's matter has not been listed today.
So we can take up these matters on Monday. On
Still that date.
All the matters can be.
There's a demolition, I'm in the item 13, there's a demolition eviction order. So on Tuesday, the date for us. So
Can it be
Monday
taken up
may be
on
too
Thursday?
close.
we can take up Thursday we matter. Yeah. We can take up in the first half.
Madam.
Thursday? Thursday, 2 PM, we can take.
Yes, yes,
Yeah.
yes.
What were you saying, Mr.?
No, I was only saying.
That's all that we pray, my lords, is let us coexist. We have nothing against their scheme.
Huh?
We have
We have
nothing against their scheme. It's a free scheme for medicines. Let that continue. We may be allowed to coexist. All that's our
We
endeavor.
will see.
Nobody
On
objects
that
to the
day,
government scheme. Nobody objects to the government scheme.
Anyway, on that date.
Government is supplying medicines free of cost.
Right.
So
Let
they have their
them give,
independent
my lord.
stores.
Anybody who wants to avail the free of cost medicine, they will avail. But there are some medicines, with due respect,
You can do it just outside the
Oh, they are having
inside the campus, they are granted us the permission, license, everything is there.
Let's say you don't have to. Short part. We'll address your lordship on that.
But only the wall after, number of shops are there. within only one sum.
Our interest is also the
That
interest of
wall,
the state.
that wall makes the entire difference.
On a lighter vein, I inherited all this from him. It all started during his time. They took
Sir,
Can
can I
you
give numbers?
please give the
Numbers, yes.
case numbers and
Yes.
all
I'll
the
collect the
cases.
numbers and give.
Hello, on matter item 57 in the list, that also may come on that. 57.
As you wish.
In order.
I have a small.
I'll also give the number.
Return 96024 may be the lead man.
960.
Great.
Item 13 also.
13 also same.
Ten, 11, 12 and 13. All are clubbed together.
My lords.
Item number 14. Ma'am, please. Ma'am.
And other cases also, if you have any other case
So
number.
this, my learned senior Mr. Mishra will.
Item number 14.
And for the, similar to that of the judgment, which is today there was, but you mentioned, it's going to come after the judgment.
My lord, I am appearing for the OP number 5 Indian Nursing Council, and the copy has never been served on us, my lord, by the petition.
We'll see later.
Ma'am.
This case on. 70 and 20th.
Bless me.
Item 15.
List and
This
Item
is this,
15.
this is this matter regarding the inquiry report of the Utkal Balashram, my lord, that apart from the inquiry report about the condition of the Balashram, my lord, your lordship said, we have done an exhaustive report you have filed, my lord, regarding the steps taken to rescue the child that went missing on 12/8/2023. There's one child who went missing, and our investigation shows that he was there for a day. He was actually found roaming in different places. He was picked up the last by the Bhadrak CWC, and then he was handed over to the Cuttack Balashram on 10th August. On 12th morning 6:45 he went missing. After which, my lord, an FIR has been filed, and my lord, I am filing the affidavit filed by the SCP, who shows, my lord, the steps that we have taken to trace out the child. And the collector has also filed an affidavit regarding
No,
this.
where is the child?
We are trying to trace him out.
Then it's very serious matter.
I understand,
Since
madam.
when the child is missing?
Since 12/8/2020.
Just think of.
23.
Yes, 12/8/2020. We have filed an FIR, my lord, the same. the
File,
everything report
file,
has
what
been
did you,
filed.
all right, you filed an FIR.
Now, my lord, your lordship will
You
see.
filed an FIR. If a filing of FIR means what?
Yes, I'm conscious of that, my lord. Your lordship, now
Filing of FIR means a cognizable offense has been committed,
363, my lord.
and
we have-
because of which that child is missing.
Yes.
And what is the investigation?
My lord, now that, my lord, your lordship will see para 6 of the affidavit, my lord, a special team has been constituted, comprising of integrated anti-human trafficking unit. My lord,
When?
my lord, we're taking one, and his photographs have been circulated.
When? This is what we are asking.
That has been taken, my lord. We are doing it on a
We are
urgent
shocked.
basis.
We are shocked. And if the child is not found within 1 week, then we shall be passing orders. This is extreme of your inaction.
Yes, I understand, my lord, the gravity of the situation, my lord. My lord, the whole thing is that I may be allowed to submit.
The
that, my lord. He was
other aspect we will be taking up later, but this is a very serious
I
matter.
may not, because he was in the
And a
habit of.
survey will have to be made. Who is heading this social, what department is that? Social welfare?
Welfare department.
Women and child welfare.
Women and child
Our
welfare.
director.
Yes, madam.
Sir, the child went missing on 12th of August. Immediately an FIR was filed.
Madam, we are not shocked only because the child is missing. We are shocked because of your insensitive approach. This is August 2023. We are in May 2024. And you have not cared even, you have done nothing for recovery of the child. Please, please.
Sir, we have been constantly in touch with his family. He has visited his father on Ram Navami in April, sir. 17th of April he has visited. But on and off he goes home and then again goes missing, sir. We have been constantly in touch.
The child comes.
Yes, sir.
To
He has
meet.
visited his home on Ram Navami. Our team had gone to his home.
All right, please ensure that the child is brought. At least the face of the child is shown to us within a week. Ask if you are in touch with the parents, please do that. Otherwise, you just think of this circumstance that they have registered an FIR. Lodging of the FIR means that there is a cognizable offence has been committed. What kind of cognizable offence can be committed? What is there in the FIR?
363, my lord. They filed an FIR under 363.
363 FIR has been registered.
Done and again.
He is saying that he comes to meet his family.
No, last they had heard that he had come to his home on Ram Navami, after which he has again gone missing.
Hearing is very.
So
Lord,
because
we will come back to your lordships, only to tell your lordships, my lord, that he had come to this place on 10th of August and he went away 2 days after.
Yes.
And before that, he has been visiting several places and staying there for a couple of days, but that is not to say that he will not be traced. The lordship may call it after a week.
The problem is that this child was there in the home.
My lord, I appreciate.
And from there he is missing. So he was in our custody. He was in our.
Right. No.
And from there he is missing.
Correct. Would your lordships call it after a week? We will come back.
Not only this, then you will have to do a survey.
Yes.
Throughout the estate as to how many children are missing.
We have already taken cognizance of that, sir. We've done a review and we have listed out other cases where the children went missing and have been subsequently found. And 2 more children, sir, we have identified. For them also, we are tracing them.
So where were they?
So one is from Berhampur and the other is from
They are missing since when?
So the dates.
All right, please.
We will file a report on this also, on the state.
Yes. So motto. Writ proceeding has been instituted under the orders of the Chief Justice based on a report dated 24/4/2024 submitted by the Secretary, Juvenile Justice Committee, High Court of Orissa. So stop. The report, apart from general poor condition of Utkal Balasram, Khapuria, Cuttack, discloses that a child aged 12 years.
13 years.
13 years is missing from the said Balashram since 10/8/2023, 12/8.
12/8/2020.
12/8/2023.
He was admitted there on 10th/8.
He was admitted in Utkal Balashram on 10/8/2023.
24 minutes.
23.
I'm sorry, I'm so sorry.
23. Mr. Parija, Learned Advocate General, has informed this court that an FIR has been registered about the missing of the child on
12/8, madam, the same day.
12/8/2023, disclosing commission of an offence punishable under section
363, madam.
363 of the IPC. Oh, stop. Next. The fact remains that after nearly 9 months, the child has not been traced. Missing child has not been traced. Stop. We have been informed that a special team has been constituted recently on
It is Integrated Anti-Human Trafficking Unit. Selma.
3rd of May.
on 3rd of May to locate the child. Stop. We express our serious concern over the insensitive approach of the authorities while addressing the issue of the child missing from Utkal Balashram. Stop. What is your name?
So Monisha.
The secretary,
So I'm director.
director,
Women and Child Development Department.
Director, Women and Child Development has informed this court that the department has taken up the issue with all seriousness and the department is also looking into similar instances in other homes. These are homes for safety.
So Utkal Balashrams.
No, other one in the state.
Utkal Balashrams.
All everywhere it's Utkal Balashrams.
So we have 17 Utkal Balashrams. We have taken a review of those 17
Utkal Balashrams are homes of safety.
Shelter homes.
So we have childcare institutions.
Childcare institutions. Childcare institutions, homes of safety are also
We have a separate.
childcare institutions in the state of Odisha. Your jurisdiction is throughout the state.
Yes.
Okay. List this case on 1 week as the first case. Stop. In the meanwhile, all concerned authorities are directed to take all possible measures to ensure that the child is located. So stop. The court shall consider passing appropriate orders on the next date as regards missing of the child, comma, if he is not recovered in the meanwhile. So stop.
May I pray one thing, madam? That this affidavit filed by the SCP, should it be taken on record or we'll file a better affidavit?
File an affidavit.
Today we have filed one regarding this. How we file a better one, if your lordship?
Well,
File
we'll
an
file a
affidavit.
better.
Affidavit, give a detailed affidavit.
Okay.
The uh, the opposite parties are directed to file an affidavit stating affidavit which also contain instances of children having disappeared from other Utkal Balashrams
My lord.
in the estate. So stop. Next. The court expects that what directors shall, comma, based on the findings recorded in the report made by the Secretary Juvenile Justice Committee, shall take appropriate steps. Please do. Why these reports have come? Why such report is there?
Sir, if I may submit. Sir, these children, if we look at their history, sir, they have been in the habit of coming to institutions and again going away, then again coming back and going away. Some of these children, sir, they are engaged in petty thefts and things like that. So they are actually not willing to stay in the homes, sir. Even in this case, sir, if we see, he is in contact with his family, but he is evading the authorities, sir. So that is the problem where we are not able to bring them back to the institution.
The why are they not willing to stay? That is the question.
Sir, in my limited knowledge, sir, it is a matter that a psychologist
Right.
should look into, sir.
Attitudinal issues also of
In this case, he was
but
counsel.
still the it says hygienic conditions not habitable.
Those things.
Sir, if we look into the detailed report, sir, it clearly says that the area where these children are staying, there the conditions are not bad. This unhygienic condition refers to the construction part where the new building construction was going on. But now, sir, we have cleared that also. All the waste materials have been cleared now. All furniture has been properly stored. Herbs and other plants that was growing there have been already cleaned. The pond has been fenced, sir, and the new building will be completed by June as per the submission of the RMDs.
All right, we'll see later.
Lordship is fixing a date. The Lordship is fixing a date.
Yes, next.
14th.
14th, first case.
Oh, please.
Yes, Mr. Pai.
That's all.
No, they have not been asked to appear.
No, I just said.
All right. It is good that you have come. You may come on the next day.
Directly.
Yes. If they want, you can join. If you want, you can join online also.
She is in Bhubaneswar. She is young. She can come.
All right.
Item number 16.
My lord, I am appearing.
Original old.
My lord, I am appearing for the petitioner, my lord. My lord, through this petition, we are challenging the extension notifications issued under 168A of the CGST Act, my lord. My lord, in this, we are humbly praying for tagging of this with the other similar petitions
It
and
will come
also.
later. When?
It's fixed, I think, 168.
168
A
notification.
168.
Extension notifications.
Yes, my lord.
Batch of writ petition were there before your lordship on 2nd of May. But
They are
from
coming on 21st.
that is not clear from the order.
21st. Let us see.
My lord, we are also
Not
praying for.
mentioned.
Last time you were appraising us, some date was fixed.
Your lordship on 2nd May, but the matter did not reach.
Oh, matter did not reach.
Yes, your
So a date has to be given.
Yes, your lordship.
134. This matter along with, we will see some date we will fix.
My lord, we are also praying for an interim relief, my lord.
Interim relief.
Yes,
Oh,
my lord.
interim relief is when?
Yes. Not to proceed. You are challenging the notice for assessment.
Original.
Order
in original.
Order?
In original.
Oh.
It's an assessment after the so called.
Demand.
My lord.
Demand.
My lord.
All right, we will pass appropriate orders.
Much obliged, my lord.
And your lordship is fixing any date to.
We will fix later.
Much obliged, your lordship.
In this matter.
You can make a mention. You can make a mention for fixing a date. We will fix it.
In this matter, my lord, I am appearing for the opposite party number 2 and 3 for the department.
What is?
I filed my appearance memo.
What do you want?
Nothing, my lord. I filed my appearance memo. My lord.
Whether the
My
interim
name
order
is-
should be granted or not.
My lord, in all cases, it has been granted.
No coercive action. Or we have not stated the demand.
Assessment order has not been.
You
In
have
the
that
next day, no course.
copy of the order last time you have.
Yes, your lordship.
Yes, my lord. My advocate on record.
Please.
No question.
That is only to be extended, no further.
Yes. No, this order was passed in your case.
Yes, my lord. In a different petition.
No.
This is another case.
Yes, my lord.
Your
Yes.
lordship.
9168 is the same party. But
Same party.
Today it is listed another case.
Yes, your lordship. There are 3 cases, and those 3 cases are tagged along.
This.
Order.
Name case is 633 of 2024. Validity.
It's our case. Different.
Yes.
Item 17.
May I please? Here, these petitioners are the MBBS student for the academic session 2019-24 years. Now they are prosecuting their study, third MBBS professional course, part 2 years. And they intend to be face their examination because of they have been let clear their part 1 examination, for which the principal LCP glance page 27 of the brief, everything is in clear LC. Annexure 4, page 27 LC for the moment LC. This is the letter of the Dean and Principal of Bhumobi Medical College LC. And the spirit of the letter is like this, that is addressed to the control of the examination, Jyoti Vihar Sambalpur. In inviting a reference to the subject cited, I am here to bring your kind notice that few students of third professional MBBS part 2
batch 2019 admission batch were not eligible to appear the third professional MBBS Part 2 exam of February 2024, as they had not cleared the third professional MBBS Part 1 examination then, Your Lordship. Now, they have cleared the third professional MBBS Part 1 examination of October 2023, which makes them eligible to appear on third professional MBBS Part 2 supplementary examination as per CBME Regulation 2023. So I am requesting you to kindly consider those students to appear third professional MBBS Part 2 supplementary examination according to CBME Regulation 2023. So we are their students, Your Lordship. So the guideline prevails also, Your Lordship, that we have to appear before them. This letter has been issued so far the control is concerned 21/3/2024, Your Lordship, seeking permission. Now the notification so far examination is actually published, Your Lordship. The notification, Lordship, that is 18/4/2024. This is the memo errors file. So
This
due
is
to
not the way. This is not on affidavit. Why should we look at it?
Your Lordship,
This is the April.
that I have taken a averment in my writ
We are
petition
in
also.
May.
I have taken a averment in my writ petition. I have already taken a averment. So
What do you
my
want?
respectful submission is that, Your Lordship, when the notice so far the letter is, Your Lordship, issued on 21/3/2024 by the Dean to the Controller General, Your Lordship, for giving permission that the students has to be appear and fill up their exam form, then appear to the examination which held to be until 10th, Your Lordship. So opposite part number 3 did not respond the same, Your Lordship, as on, Your Lordship. So for this index, Your Lordship, we are unable to appear our examination held to be 10th, Your Lordship. My respectful submission, Your Lordship, we may be permitted to appear the examination subject to result of the writ application because the urgency is needed, Your Lordship.
Yes,
Because the
we saw the
guideline is
state.
in our favor, Your Lordship. The guideline so far, appearance in the examination.
Who is for the state? What is it today? 7. Who is for the state?
State is the party.
It is
No,
not.
state is not a party.
Controller of examination.
Sambalpur University is the party to the proceeding, Your Lordship.
Chief
We
Controller
offer a
Sambalpur
copy to the Sambalpur University advocate, but he said that unless until notice has been issued, we cannot appear, Your Lordship.
National Medical Commission.
And there another council so far the National Medical Commission, Your Lordship, they are also saying so the notice is required unless until notice, because so many councils are there, Your Lordship, to whom the authorities get made engagement, they do not know. So therefore
If
they.
is concerned, we can appear. Let him serve a copy. I'll obtain instruction by tomorrow. But so far Sambalpur University concerned,
Sambalpur University is the.
some councils are there, Lordship direct, they will serve a copy so that it will be taken up tomorrow. By tomorrow, they'll obtain instruction.
Opposite party number 5, Director National Medical Commission.
No, and this controller of who appears for the controller?
Sambalpur University, Lordship.
Sambalpur. Huh?
Sambalpur University.
Yes, ma'am.
Sambalpur University, Mr. Partha Sarathi Naik is appearing. Mr. Partha Sarathi Naik is appearing and Sanjeev Udgata is also appearing.
So ask him to be here at 2.
Mile.
All right. And ask him also to inform the controller of examination about this. Serve a copy upon him.
Okay, just now I am serving, Your Lordship.
Mr. Satpathy, are you not appearing for University, Sambalpur University?
Yes, I have a panel here, but they have the panel of councils. So let's see which one
All
it is.
Considering the urgency of the matter, we request and so to say name. Sorry, I have very poor memory of names.
TK Satpathy.
TK Satpathy accepts notice on behalf of Sambalpur University. So stop. As the matter relates to third to part 2 supplementary examination. Third professional MBBS part 2 supplementary examination, which is going to be held
10th, Your Lordship.
On 10th of May 2024. We request him to seek instructions from the controller of examination as regards his response pursuant to later dated 21 or 31?
21, your lordship.
21/3/2024, issued by Dean and Principal,
Yes, ma'am.
Bhima Bhoi Medical College and Hospital, Bolangir, bracketed annexure 4. Stop. The matter, notify this matter tomorrow within first 5 cases. Tomorrow.
Bhimabhoi Medical College, you are not appeared.
No.
It's a private institution. Bhumabhai, in fact, it's a private college.
No, your lordship, this is coming under your lordship, medical college coming under Sambalpur University, your lordship.
Is it a privately managed college?
No, your
It is
lordship.
a
it is
government college.
Government college, your lordship.
All right, so government, he has written a letter to the controller of examination. Just see to it.
Yes, sir. Day after, 1 day.
No, let it come. We will grant you further time.
Yes, sir.
All right.
Yes.
If the matter is taken up tomorrow, you can ask your controller of examination he may join online. So these are urgent matters.
Yes.
So if the petitioner has genuine case and if he fails to appear in the examination, that will cause heavy loss.
Correct.
So therefore, but if you deny, if you reject, then no problem. We will see whether it has any merit or not.
I'm requesting Lord kindly send all this petition through
Please
email.
do it.
Applied,
Sir,
every
soft
copy
copy
is-
so that I can immediately send it
So
just
give the soft copy.
in my mail ID so that it can be.
Give the soft copy of the. So
I'll
that he
apply
can-
it. Just now I was getting of it.
Yes, tomorrow.
My entire grievance is OP number 3.
us see,
Due to
let us
delay of OP number 3, and also we are depriving.
OP number 3 is controller.
Controller
So
also.
he has.
Duly obliged.
Item number 18.
May I please be honored? The claim of the petitioner is that the challenging the inaction and illegal action not raising up and searching of the husband of the petitioner. The case is not only that the petitioner husband, Raghunath Naik, is a daily laborer and he was maintaining his family from the daily wages. And
Mr. Did you file any FIR?
yes,
When?
I filed on FIR by the Annexer 1
When?
in 2015.
2015.
Yes,
you
but it
filed
has not
FIR.
been registered.
Huh?
Thereafter, I approached before the legal aid authority, and legal aid authority give direction to the superintendent of police, and I also filed a application before the superintendent of police. Basing upon that, a case was registered, and the case is now pending before the SDGM Udola in the district of Morganj. But those person, those labor contractor who has sent him to the outside of the state, but no action has been taken against them. Because till now we are in darkness that whether the petitioner husband is on alive or dead.
The FIR was lodged.
Yes, my lord.
Charge sheet was submitted.
Charge sheet not been submitted.
You are saying the matter is pending before the court.
Out of SDGM Udola. SDGM Udola and district of Morganj.
Charge sheet has not been submitted.
Yes, my lord.
How charge sheet can be submitted? Unless someone is found guilty or some evidence is there, charge sheet cannot be submitted against someone.
Because those person was
Sir,
taken him.
Please try to understand that because some crime has been committed, someone must be punished. This
Yes,
is
my
not
lord.
the law.
Yes, my lord.
All right,
But
then
no
what
action has been taken against those persons, the labor contractor, those who are sent him.
Which person?
OP
Against
number 4,
which-
my lord.
OP number 4.
Yes,
OP number 4 had done what?
he is a labor contractor. He sent me to the district of Andhra Pradesh for more income and engaged me in a silk industries. And there, the petitioner's husband is missing.
So you are convinced that he has committed the crime?
Then I inquired the matter, the petitioner inquired the matter and went to the Andhra Pradesh and came to know that he has and not find his husband. And he went to the police station to lodge an
How
affair.
is he responsible?
Lord?
How is he responsible? The person who had taken him to Andhra Pradesh
Yes, my lord.
for some work, how can he be held responsible?
Because he has sent my husband.
So,
He has sent my husband as a labor contractor to work on the silk industries located at West Godavari district.
the whole difficulty, Mr. Counsel, is that you are talking like your client. You are a counsel.
The
So you
police have
have
not
to-
given the counter, my lord, till now.
Where is the question? What is the purpose of counter? You have filed this writ petition 9 years after your husband went missing.
Because I inquired the matter and I sought here and thither, but not
You
found
are
him.
inquiring the matter and you are doing everything. And what is the the meaning of this habeas corpus?
My lord,
What for this writ is issued, habeas corpus writ?
the requisition to pay products on my husband to direction given to the police station. If I lodge FIR before this local police station, and he should
Sir,
make an
you have
inquiry.
filed this writ petition seeking issuance of writ in the nature of writ of habeas corpus. What is habeas corpus?
Because my sole grievance in this petition, because he has sent by someone. Somebody has taken him.
Sorry.
The OP number 4 has taken my husband.
The petitioner asserts in the present writ petition that her husband went missing since 28/6/2015 from Silka Private Limited, West Godavari district of Andhra Pradesh. Full stop. This writ petition has been filed seeking issuance of a writ in the nature of habeas corpus, directing the opposite parties number 1, 2, and 3 to produce the petitioner's husband in this court. So stop. Next. It is not the petitioner's case that her husband was ever in custody of the opposite parties number 1, 2, and 3. So stop. It is rather her case that respondent number 4 had taken the petitioner's husband in the name of giving him job to Andhra Pradesh in 2015. Stop. The petitioner's husband was working in Silka Private Limited in the district of Andhra Pradesh till 28/6/2015. He was working.
Yes, my lord. 28/6/2015.
He was working.
He is working there.
And thereafter.
Yes.
Stop. How this writ petition can be maintained here in Odisha? Stop. Next, the writ petition, comma, in the background of the facts as noted above is wholly misconceived and is accordingly dismissed.
Item 19. Item 19.
Item 19, and today we also have finalized the lots of preliminary so-called affidavit, wherein we have now finalized the gradation list. So far as promotion of these petitions are concerned, it will take some time because of the ensuing election. The commissioner is busy, and furthermore, DPC will also take some time. But gradation list has been finalized, and promotion shall be given. It will take some time.
Yes.
Kindly see the last order.
We are pursuing your case, Mr. Counsel. What
My
more
lord-
can we do?
My lord, neither they have filed a so-called nor compliance affidavit. Let them file, we'll respond.
All right. By way of last intelligence, time till 24th of June is allowed to the contenders to file so-called
and compliance affidavit.
So-called and comply with the order of this court, violation of which has been alleged in the present contempt application. Yes,
It will come on 24th, my lord.
24th. This is matter on 24th.
2004. I'm giving a copy to my friend. The order has been passed on yesterday only, giving promotion. We may go through it, not satisfied that not so.
Let it come after.
No, see the order.
Your lordship, in this case, my writ petition was allowed. I have a prayer with the financial and consequential benefit. I am retired since 2013, but till date my retirement benefit has not been released.
Let us see what is the order.
Your lordship can have glass page 19, my lords. Paragraph 16.
So,
my writ petition was allowed, my lord.
Then
my writ petition with a prayer to release all the financial and consequential
Mr.
benefits.
Where is the direction that you shall be given all consequential benefits?
In writ, I have a prayer.
Prayer is different.
My prayer.
Don't go by that. They are doing it. Let them do it. Otherwise, they may take a plea that there was no direction for giving you any consequential benefits. Therefore, they are not required to do anything.
My pensionary benefit has been held up, my lord.
There is no direction for payment of pensionary benefits.
In my writ was allowed by this division bench.
Please see the order. We have to see the order passed by the court. Come to paragraph 16.
Therefore, so far the third question is concerned, as there is no illegality in the appointment of the appellant, writ petition, in our considered view, no action can be taken against the appellant writ petitioner. As consequence of the above observation, we set aside the impugned order dated 17/7/23 in writ appeal. The writ petition WPC OAC number 48 of 2012 is allowed. My in writ 48 of 2012, my lord, I have a prayer to give all financial and consequential benefit. That was allowed by this.
They are doing it. There is no such order. The order is the order dated 17/7/2023 has been set aside. What was that order?
That was London single judge order, my lord.
So I have given the compliance order. People also kindly look at all the benefits have been given. Your Lordship filed order dated 2/5/24. He was, all the proceedings against him have been dropped, Lords. And thereafter, Lords, letter dated 4/5/2024, he has been given, Lords, annual increment from the date of return, all increment till
What do you want?
2004. And thereafter, Lords,
Retirement benefits release, my lord. I have retired since 2013, my lord.
Sir, please try to understand. We are not sitting in writ proceeding. We have to just see what was the direction and whether that direction has been complied with or not. Run AGA representing for the contemners has produced before us a communication, an office order. Office orders dated 2/5/2024 and 4/5 and 3 and two other.
no, three
Office
other
order
orders dated 4/5.
2/5/2024, whereby the disciplinary proceeding against the petitioner has been dropped. In the light of, in compliance of this court's order dated 11/9/2023, passed in WA number 1929 of 2023. Stop. By order, office order number 4/5/2024, issued by memo number 1539 from the office of the settlement officer Cuttack, Major Settlement Cuttack. The petitioner has been given notional promotion to the post of inspector with effect from 2/8/2004. First of further, by another office order issued by memo number 1533 dated 4/5/2024, the increments have been allowed in favor of the petitioner under ORSP rules 1998. Stop. All the actions have been taken in compliance of the aforesaid order of this court dated 11/9/2023. Stop. Next, the present contempt application has been filed alleging disobedience of this court's order dated disobedience of the aforesaid order of this court dated 11/9/2023. Stop. 2023. Operative portion of which reads as under paragraph 16. Stop. Next, considering the on perusal of the aforesaid office orders issued by office orders, we are of the view that no case of deliberate disobedience of this court's order is made out. Stop. The contempt proceeding stands stopped accordingly.
Item 21.
May I have a lordship?
Complied.
Yes, in pursuance to the earlier, there was the first contempt loss. in the direction, the order has been compared with Miller's. FIR has been lodged against the person who has taken the amount of the petitioner Miller's by impersonating, and another OPDR proceeding has been initiated for recovery of that amount Miller's. That is the
Complied with?
instruction given Miller's.
Yes, yes, my lord. Well,
Complied with.
our land already acquired, my lord. Till today, I have not get any compensation, my lord.
So what is the order?
Page 8, my lord. This is
To consider the representation that
My
has
lord.
been done.
this is the only our residential house.
Mister, please come to the order.
My lord, my lord.
Paragraph 5.
To consider representation, my lord.
Complied with.
This is the second content. The second content.
Maybe.
No, first, you complied the order since 23 minutes. We have already come to pass the order since 23.
Item 22.
22 minutes. It's the central government minutes.
My lord, as per your lordship's direction, I have sought a copy on my learned friend. And this is relating to non-compliance of the order under Annex to 1, page 9 to 13, relevant portion, page 12. Page 12, last 5 lines. Seeing the representation of the petitioner under Annex to so and so form part of the petition, this court directs that OP number 1 shall take into consideration of the same and pass appropriate order in accordance with law. Because there
Now
is
you are reading which page, paragraph?
page 12, last 5 lines.
Paragraph
Keeping in
7.
view.
Yeah, keeping in my lord, page 12, para 7,
Yes.
para 7, last portion.
Yes.
Since the representation of the petitioner under Annex 15 and 16 form part of the writ petition, this court directs that OP number 1 shall take into consideration of the same and pass appropriate order in accordance with law, because there is a need of Swadhar home or Saste home or both, as the said solemn conscious decision has been taken by the project sanctioning committee
There
within
is
a period of 3 months.
We are not able to see that. You are referring to paragraph 7.
Yes, my lord. Paragraph 7,
but,
page 12, page 12, last 5 lines.
Yes. Mrs.
Since-
J. Sahul and Central Government Council contended.
J. Sahu, my lord, thereafter.
Keeping in view the environment.
Considering, my lord, thereafter, since
the
representation of the petitioner,
Yes.
got it, my lord. Under Annex 15 and 16 form part of the writ petition, this court directs that OP number 1 shall take into consideration of the same and pass appropriate order in accordance with law, because there is a need of Swadhar home or Saste home or both, as the said solemn conscious decision has been taken by the project sanctioning committee within a period of 3 months from the date of production and communication of this order. It was communicated by Annexure 2 and 3.
The order has not been passed.
Nothing has been passed.
The central government wrote a letter, this page 19. What I presume that the last page 13, the project sanctioning committee, that is the state government. That's why perhaps they have written letter to the director, is written letter to the concerned ministry of state government. That it is stated the reference to the government may kindly examine and send a recommendation with regard to the pertaining to the Indian Society for Rural Development, Ganjam, Odisha, for funds under the Sodara home at district Ganjam in the list of the above mentioned code order, and advise this Shakti Sadan scheme guidelines under the Mission Shakti, as you are aware with such and such. So, but direction is given to OP number 1, my lord. I will consider this.
Who is OP number 1?
Who is the Secretary, Women and Child Department?
Ministry of Women and
Ministry of Women and Child
Child
Development Department, Government of India.
Government of India.
But the order has to be complied with. My lord, you are required to pass an order.
My lord, may I pray, my lord, let me give some time. In the meanwhile, I will look up already I wrote a letter, then I. 3 weeks time may be given. 3 weeks time may be given.
3 weeks should be easy.
3 weeks time is allowed for the contemners to file to inform whether this court's order has been complied with or not.
Lords may kindly fix a date for this.
It will, you will.
Oblige.
Item 23.
This item number 23, I had directed him to dispose the equipment and he has said that he will be coming with the instruction launch notes or let it be taken up tomorrow so that I can give to my friend.
Tomorrow.
Item 24.
24 minutes, here I pray Lord may grant me some time because there was a direction to consider the case of the petition in view of that Raghunath House case and take a decision. The chief engineer who is supposed to World Bank decide the case. He has joined recently 2-3 days back. I had a telephone meeting. He needs some time. After the holidays,
As requested on by learned AGA to seek instructions as regards full compliance of this court's order, violation of which has been alleged. The present contempt application is this matter on after holidays. 27th.
Yes.
Published June.
For orders item 25. Item 25.
Yes, state. Yeah, it's still surviving 18 years after.
But civil.
Where is that?
That is 807. Digital page. The code of practice, civil appeal. Plan A.
No one is there, then why should we can dismiss it for default? So, 2006. Why? This was from default. Yeah.
Well, କେବେ ହେଇଛି? But it should have gone up. Supreme Court ଫେରିଲା ନା? Is the position Amarinder Kumar Mahapatra? This matter relates to that stipendary engineering case. So they have got the relief. So why is it pending here?
No one is pressing, then. It's positive. There is no representation on behalf of the petitioner to press this application. This application is accordingly dismissed for default. So we make it clear that petitioner should be at liberty to make an application for arbitration. So, it can matter if required. So stop. Yes.
Item 26.
Though it's an application for recalling, in fact, I don't seek to recall the order by my lords, my lord. It's only a little modification will do it. If your lordship see order dated 4th of January 2023, the writ petition was disposed of. Could I hand over the certified copy of the order?
No, where is that order?
Lordship has got it.
4/1/2023.
4th of January 23.
Which annexure?
But it's an
in my
it's
counter
an
I have quoted. That order I have quoted in page 2.
in my this is the order. I have only one copy, my lords, may kindly.
Honorable Apex Court.
Lord, I understand. I do not want any order. I just need, Lordship may grant me liberty, I'll approach the
So
bank.
they
That's
have
all.
remanded, they have remanded us.
Lord, I do not want any interference. Lord, I seek a liberty to withdraw it with a liberty to approach the bank. That's all. I do not, I know Kushya Chandra Mahapatra, ICICI Bank. I am conscious of those judgments, my lord. So I will not.
Today I have filed my counter affidavit in this case.
No, but he doesn't want, he wants to withdraw the.
The state order which he seeks to withdraw it, that was passed by his request. On his request, that order was.
He is not saying anything. He is withdrawing the this writ petition.
IA. Even IA.
The IA.
Yes.
IA is not maintainable
That's
because the order which he seeks to be
Recalled.
modified, that was passed at his request.
Yes, yes.
And the writ petition is also not maintainable in view of the judgment I have given the copy 22.
Writ petition there.
5 basis.
We can just dispose of the IA.
Right, my lord. They disposed of matter. IA have filed to recall. I don't press recall. I just have to liberty. I'll approach the court. I mean the bank. That's all.
Learned counsel for the senior counsel appearing on behalf of the petitioner does not press IA number 1889 of 2023 and seeks to withdraw the same. So IA number so and so stands dismissed as withdrawn. So
Liberty be granted to approach the bank. That's all.
yes,
That's, I think there should not be any.
Let him approach the bank.
Right.
Let him approach the bank.
learned counsel for the opposite party does not oppose the prayer made on behalf of the petitioner that he should have liberty to approach the bank. So, with the said observation, the IA number so and so stands dismissed as withdrawn.
Grateful.
Item number 27.
My lord may kindly see flag N of the writ application, my lord, flag N. This is my substitution petition. What has happened, my lord? Petitioner died during the pendency of the writ application, my lord. Where now the widow has come to prosecute the case on behalf of the petitioner. So I have filed this substitution petition. I pray, my lord, it will be better if your lordship grant me liberty to file a better fresh writ application because petitioner is dead. Wife will file. Or she may be substituted. Even if I have filed a recall petition, I am filing a recall petition today because it has been dismissed for default. During pendency of the case, my lord, it was default on 1/2/23, dismissed for default. So it will be better. Your lordship may grant me liberty. I will file a fresh writ application because now the husband is petitioner is dead. Wife will.
WPC number 18078 of 2000. This writ application was dismissed for default on
1/2/23.
On 1/2/2023. Stop. It has been stated at the bar that the petitioner is no more. Stop. Then what? We cannot do anything.
His wife will file a writ application because substitution she has filed.
And
That is that flag N.
An interlocutory application wide IA number 5272 of 2024 has been filed by the petitioner's widow for substitution. as according to her, the cause of action survives despite death of the original petitioner. So stop. Next, learned counsel for the learned counsel who has filed IA number 5272 of 2024 on behalf of the widow of the petitioner submits that he shall not press this application if a liberty is given, file a fresh writ application so stop. This IA number so and so 5272 of 2024 is dismissed as withdrawn with the liberty as sought.
Obliged, my lord.
I am applying for open number 4, madam.
Opinion number 4.
28.
Item 28, my lord. The notice on response note 6 is not a return. I'll take fresh step. By previous order dated, I have been directed to file postal liquidation response note 6. I had filed, but no AD is returned. I'll take fresh steps.
On whom?
Response note 6, madam.
Item number?
Item number?
Item number 28.
28.
And he is appearing, I
May I please exit? I am for the opposite part number 6. I am just appearing in 3rd May 2020.
I'll solve.
I am appearing 3rd May. I may kindly pray for that regarding for some time filing of counter affidavit and objection.
No, but this appeal is defective.
Yeah, let's see, there is a defective regarding limitation. Yeah, that's notice is issued on limitation.
So what is the delay?
The delay is the steps 44 days. Yeah.
You are representing respondent number 6.
Yes, sir.
Then he is appearing.
Yes, ma'am. I'll solve it.
And we can condone the delay.
Let's see, may kindly permit some time.
44 days delay, Mr. Khan.
Let's see, may kindly permit some time for filing.
54 days.
Yes, sir.
Learned counsel for the petitioner and learned counsel representing the opposite part, respondents, including respondent number 6, who has entered appearance by way of wakalatnama. You filed your wakalatnama?
Yes, sir. On 2nd May 2020.
54 days delay in filing the present writ appeal is hereby condoned. What is defect number 5D and?
I file separate vocabulary for the appellant. I was the advocate for the petition in the read petition. So I have to file separate vocabulary for in the read appeal. I'll file that.
So have you filed?
I have not filed. I'll file.
Then why let the defects number 5D, E and 9 be removed within a week? Failing which this appeal shall stand dismissed without any further reference to the bench. Yes.
Item 29.
It will form after holiday. You first remove the defect, then it will remove the defect.
Item 29.
Item 29, there is a delay of 258 days, but similar matter that is regarding work charge employees, that WF 432 of 2022 is pending for my lords. So it may come after that, it will come that decision in that 432 of 2022 it will cover all the matters. That will, if that matter is decided, it will be covered. So that limitation part, and my learned friend is also appearing in that case.
In that case, delay has been condoned in 430.
That I am saying so.
But in this case, 250 days more delay.
If the principal is decided in that case, that only one point involved in that case, work charge employee, not regularly whether entitled to pension or not, in view of pension rules 1992. That is to be decided, but if your lordship will fix that 432, that can be decided all the issues.
Where is that matter?
That was for last week. It was listed on Thursday, it has not come this week. So I am praying also that matter can be taken up if your lordship may fix it to tomorrow, so that matter, a number of matters are there. The matter can be, all the matters can.
Following judgment rendered in earlier rule.
Yes.
Many cases have been
and also my
disposed
lord,
of.
yes, my that in our rule, in pension rules, that says if a work charge employee is regularized, then he is entitled to pension.
But matter was heard, no?
Yes, my lord, that my learned advocate general was arguing that matter, and your lordship has fixed that matter, that has not come. So I am trying that matter. What has happened, my lord, is that the judgment in Norsu Pradhan that has been relied in all the cases. In that Norsu Pradhan case, neither the rule 18 of the pension rules has been taken into account. And the Honorable Apex,
Confirmed by Supreme.
but that SLP was dismissed on the ground of
SLP
delay. Yes.
delay. So there is no merger.
No,
Thereafter in 2023, on merit also, some judgment has been passed by Honorable.
And my learned friend is saying that in 2024, one judgment was, an order was passed here on the ground of delay that was dismissed, that has been stayed by the Honorable Apex Court. And he knows everything, that all the matters are not decided taking into account that rule. And my lord has had the matter for some time when learned advocate general was placing that matter. If that matter is decided, all the matters will be solved, my lord, whether they are entitled to pension or not.
Make a mention tomorrow.
My lord, obliged.
Let me read topic copy and along with the limitation copy we serve.
I am serving just now.
Take that. List this matter on 4 weeks after vacation.
And I'll make a mention that 432 of 2022 tomorrow, my lord. But fixing the matter.
This is not tagged up.
No, I am not. I am not. I am saying that if that matter is decided, all the matters will be decided. That I am submitting.
Item 30.
In item 30, my lord, may I pray, your lordship, this is a matter, this has come for limitation. This is a fit case, your lordship. Last occasion, your lordship has instructed me on a limitation matter. Your lordship will hear this matter and learned advocate general will argue this matter. May I pay your lordship may fix it tomorrow, my lord, 30 and 44. In 44, your lordship, if you're on that question of Surama Mandir, your lordship wanted to know that Surama Mandir and the subsequent judgment of the, this is a case, my lord, this is squarely covered by lord's judgment. That during pendency of departmental proceeding and criminal case, one is not, and that I am squarely covered by this. But only one problem here, my lord, there is a limitation. So your lordship,
Joseph Barik.
Yes, Joseph, my lord's judgment is that in that Chakradhar Prasad Gantat case.
I don't remember.
My lord, I'm so sorry.
Of this High Court.
My lord's judgment.
This
Here-
High Court or
Yes,
Patna?
no, my lord, this side. Here, Chief Justice.
The Joseph Barik is
Yes,
a
Gaurav,
reported case
yes.
already.
Joseph Barry case, relying that Joseph Barry case, and my lord is the party to that.
Oh,
But this is a case, there is a limitation. So if in such type of cases, further limitation can be condemned, your lordship can hear this matter on the question of limit that taking into account that Surana Manjari Das case. If this matter and item 44 will be fixed to tomorrow, on that question of limitation, your lordship can hear this and learn the advocate then will argue this matter.
My lord also remember, my lords also opined that when it refers to relates to a policy decision of the government, large number of repercussion is very large, like vouchers, like job contract. Repercussion is very large, my lord, because whether somebody is entitled to it or not. If that question, all these writ petitions have been disposed of.
that is one of the questions, but another question is that see, after all, these appeals are filed by the state.
Yes, that the larger
Okay.
question. Well,
So appeals are filed by the state. If because of lapse of any officer or any employee of the state, the appeal could not be filed on behalf of the state, then this court may consider condonation or delay subject to subject to this thing, you take this stand that you shall be taking some action against the person.
Hiring officers
yes,
who
If
have
you-
delayed,
yes,
maybe
if you
deliberately
take
or
that-
otherwise.
if you take that plea, because after all, state is not a person. So state is a sovereign body. Appeal filed by, of course, the state has to be careful.
Yes, ma'am.
That the appeals are filed within time, but because of lapse of one person, the cause of the state cannot be said to have vanished. So
Giving an example,
that is the logic.
In income tax matter, 3-line order of Honorable Apex Court, only 3 line, 3 judges bench. If stake of revenue is high, then
yes,
the point of law has to be decided.
yes, my lord. On last occasion, my lord has also
West
pointed
Bengal
the law-
infrastructure matter.
point of law is not decided only on the state is a appellant. So only on the ground of limitation that matter should not be. So your lordship wanted to hear this matter from
I don't know which way will I go.
But you always take that same stand which Postmaster General.
Yes, ma'am. I have seen that judgment and
file passing bucks will not.
Yes, ma'am. Subsequent judgment has come that your lordship has seen that on my learned brother, Mr. Mahapatra was relying on judgment that Honorable Apex Court has condemned the delay of 760 days or 460 days. So thereafter, your lordship said that matters will be hard that taking into account that Surana Manjari Das case.
Surana Manjari Susrit case, I think,
That
Honorable Apex Court.
Another judgment of that 2020.
Mahanadi Coalfield case of this court followed Susrit and condoned the delay.
Yeah, that
I
if your
faintly
lordship
remember
will
in
fix it to tomorrow,
2014-15.
on this point it can be discussed. Tomorrow, Mel. Item 30 and 44.
30 and 44.
In 30, I have also filed my objection. I am appearing for the respondent.
We will see.
There's a delay of more than 380 days. And during the pendency, the respondent has been exonerated from the charges in the departmental proceeding. On the same charges, department proceeding was initiated. Later on, first, the vigilance case was initiated. The trial has not commenced in the vigilance case till today, my lord.
This is covered by this judgment.
That is,
My
he has
learned-
been
Why
exonerated
is
from
it
the
not
department.
commenced till that?
My learned may go through this judgment.
But he has been exonerated from the department
Yes,
proceeding.
in this case also, he was exonerated in the
No,
department.
one thing you have to see that whether it is for the latches of the department or for the time taken by the party concerned. To delay the trial proceeding.
As per my instruction, the witnesses are not turning up in the vigilance case. For that reason, the trial is not being commenced.
Since when the trial is pending?
That updated instruction I will provide tomorrow.
Yes, tomorrow for the matter.
30 and 44.
30 and 44.
Item 31.
Objection.
31, my lord, is covered by my lord's order. And was someone has appeared in this case because no one has appeared. When Prafullo Kumar Mahapatra has appeared because there was a delay, my lord.
Someone has appeared?
Yes, my lord. Prafullo Kumar Mahapatra, his name appears.
He's a regular practitioner here.
Regular practitioner, his junior was here sometime before. I'll intimate him.
He is always sincere also.
Yes.
All right, tomorrow, no one appears on behalf of the respondent.
32 also Sarat Pradam. My friend appeared.
Item 32.
Yes.
Delay.
Delay of?
Delay of more than 150 days.
Report here and March part.
The fact is that this my order has been passed by the honorable single judge to extend the pensionary benefit, and now the REIT appeal is there. And now, in the meantime, the matter has been remanded to hear the appraise, and now the judgment has been also passed.
Say order
My humble submission is that in this process, your lordship do something for after retirement. They are not giving single pie, but now they are now this REIT appeal will be disposed, and then they will again this matter will be remanded to the single judge, and again the judgment will be passed, and again they have to face the REIT appeal. This is my you also can have a glance of the judgment passed by the single judge. This is the something must be done again and again. They have to approach the court.
They can, because they can afford.
This is the judgment. I have given the extract of the copies, the judgment and the relevant pages. If the matter is to be remanded, then the judgment has already been passed by the honorable single judge. The lordship kindly have glance at the one page 180. What's the last? I'm giving my lordship.
No, but what do you want to say?
My lord,
What do you want to say?
my lord, since challenging this order also, this judgment, the REIT appeal has been passed. So something must be done. More than 20,000 employees are in the similar footing. So if the appeal has been filed, so the hearing should be made, and your lordship may pass in judgment. This should be at least the appeal should not be harassed. My entire endeavor is there.
Yes, what do you want?
My lord, if my friend is ready for hearing on the matter, I am ready.
Hearing, I am
If
not
you want
thinking-
hearing, we are ready, man.
Right.
My lord, my kind of the order at page 45.
Right, that must be the total joint here, hearing the judgment.
Let the delay be known, my lord. I'll be ready for hearing.
Let us see. This is the order 9/12/2022.
My lord. The petitioner has filed this application seeking direction to the opposite party number 3 to sanction and release pension and pensionary benefits in the light of the judgment rendered in Sarat Chandra Polda versus State of Odisha. 2015 to ILR Katak 94. As it appears, the issue involved in this case is analogous to WPC number 22316 of 2018. Therefore, in view of the reasons assigned in order dated 28/18 passed in WPC number 22316 of 18, until this writ petition stands disposed of. The
Yes.
petition having stood in the
Where
same.
is that? WPC 22316?
22316 is a similar order, madam.
Where is the final? There must be one order. Is WPC 22316 is not.
Most humbly, I will submit, my lord. In no case there is a final finding, except Sarath Chandra Parida case.
Where is Sarath Chandra Parida?
Sarath Chandra Parida case, my lord, is 2015 to ILR.
This is the judgment with for your lordship kind of appreciation.
Just a minute. Sarath Chandra Parida 215 ILR.
Katak 9 page 94.
Yes. Yes.
My lord will, unknown the delay, my lord may fix the matter
No,
tomorrow.
no. What is the Sarath Chandra Parida? We'll see.
Sarath Chandra Parida case is a case, my lord, where this honorable court held that an employee of the block grant school, an employee of an institution in receipt of block grant is entitled to be considered for rehabilitation assistance scheme. No.
Don't do it, please, please, please allow him.
Rehabilitation? Sarath Chandra Parida case, my lord, is entitled to get pensionary benefits. Now, our specific case before this honorable court is that the 1981 rules envisaging the pensionary benefits in favor of the employees of aided institution is not applicable to the institutions in receipt of block grant.
So what is your stand on Sarath Chandra Parida?
Sarath Chandra Parida case, my lord.
Whether it correctly decides the law or wrong?
Our humble submission, my lord, it doesn't correctly decide the law.
That is confirmed.
Now, all the cases where
in Supreme
it is confirmed in Honorable Supreme Court. Now, all the cases which relies upon Sarath Chandra Parida, we are taking a stand that the issues we are raising has never been answered, has never been raised in Sarath Chandra Parida case. That is our case, ma'am. We say these are the legal issues. Yes, now the judgment has come of the Honorable Single Judge dealing with the issues we have raised. That is under challenge before this Honorable Court. Writ appeal. Our state specific stand is, my lord, that day also I was submitting about applicability of the 1974 rules. My lord, as in 1974, the legislatures could conceive that there are types of aided institutions. Now, a judgment has been passed, taking as if all aided institutions are one type. Also, my lords, if my lords will hear this case, I am ready because I was also conducting the hearing of that case. Now, question is, my lord, in 74 itself, if a rule provides this type of
whether Sarath Chandra Parida has been taken into account in this case, Hemant Kumar Chaudhary.
Yes, yes. Hemant Kumar Chaudhary.
Hemant Kumar Chotra has been, now the judgment has been passed wherein we have raised all the issues and that has been answered by the Honorable Court. That is under challenge before, in the writ appeal.
This order is under challenge.
My lord?
This order is 12/1/2024 is under challenge.
Yes, ma'am. Yes. It is pending in the writ appeal, passed, filed by the state. My entire endeavor is that.
And if so, if therefore, my lord,
this order has been challenged in which appeal?
That is that writ appeal number I will give, man. I will provide that. You have number? I will provide that number, my lord. During lunch hour, I will provide.
Reference 2024 1 ILR in March part Kali. 1007 की कौन?
So, but what is the legality in this order, which you are challenging 9/4/2000, 9/12/2025?
My lord, the petitioner is the only case that I am covered by Sarath Parida. That's all, my lord. He has not, by any procedure of law, to establish the right that he is entitled to pension under the 1981 rules.
No, but if he can establish that he is covered by Sarath Chandra Parida, and if that has been followed,
My lord.
then what wrong has been committed by the land civil?
Exactly, my lord. I will convince this honorable court that he is not covered by Sarath Chandra Parida. That is my endeavor. That is my entire case.
Your
My lord, may I submit? There are two cases.
So we will hear you on
My-
merits.
no, only for your lordship's kind appreciation. There are two cases in which already the state has been giving pension. One is Sarath Chandra Parida and another is Sarath Chandra Pradhan. In that Sarath Chandra Pradhan also, I was doing that case. Your lordship kindly have a glance in Sarath Chandra Pradhan's case. It has also been, the judgment has been passed that taking into account the Sarath Chandra.
No, we will come to the merits later.
My lord.
It is his submission that Sarath Chandra Parida does not apply in your case. This is one. He may be correct, he may be incorrect. But that is a question which requires consideration.
That, my lord.
Sarath Chandra Parida case, Sarath Chandra Parida was under grant in aid. Hold.
No, it is all well pension. The matter was when they, after retirement, although in the name of, in their stand is that as they were getting block grant, so they are not entitled to get a single pie towards pension and also gratuity. So challenging that inaction, the Sarath Chandra Parida and Sarath Chandra Pradhan, they prayed that the pension should be given. And the Honorable Single Judge has passed in both the matters that the pension should be given within 4 months. And challenging that order, without filing this writ appeal, in those two cases, the state filed straight away SLP and they lost there. So finding no alternative, both the petitioner Sarath Chandra Pradhan and Sarath Chandra Parida, they have been given pension and they are getting pension.
Last in Supreme Court on merits or on technical?
On limitation ground. So on that ground, so now thereafter, all those things, and my humble submission is that I'll show that.
So Sarath Chandra Pradhan is Sarath Chandra Parida is a single judge decision or division bench?
I'll show how the state is taking different stand at different times. Only one paragraph.
That we will see later, but fact remains that this is based on Sarath Chandra Parida, which is a single judge decision. We will see whether it does lay down the correct law or not. You can examine. And whether your case was covered by that or not.
And Sarath Chandra Parida case, you have implemented.
Yes, ma'am. In both the cases, the SLP was dismissed on ground limitation. I have Sarath Chandra Parida's case. Judgment is there.
All right, but in the meanwhile, we will have to condone the delay first, then we will consider.
My prayer is that all the cases should maybe tagged together.
Instead of tagging together, let us lay down law in one of the cases. And thereafter, as you have been doing, I will also do dispose of the later.
But that was my intent is that since the more than 20, every month, 100 and more than 100, 200 employees are retiring and they are facing harassment. Either or, your lordship up to.
We will decide.
Yes. So more than 20,000.
We will decide. We will decide one case of your. It seems that you are going to give us a very good assistance. Therefore, we will decide that matter in your case.
No, in that Hemant Kumar Chotra case, I was the leading advocate there.
We understand.
Yes, yes. It is up to you.
There is delay of 155 days.
155 days.
155 days in filing the present intra-court appeal. So, we have heard learned counsel appearing on behalf of the appellant and learned counsel representing the contesting respondent. Stop. Considering the explanation put forth in this application, seeking condonation or delay, the same is allowed in the interest of justice. Stop. The delay in preferring the appeal stands condoned. Yes, list this matter for admission on after which. As first case.
I don't know, 33.
There is a delay in filing the appeal, Your Lordship, the state appeal. There is a delay in filing the appeal around 270 days. I'm so sorry. I'm so sorry.
In this case, my lord, on the last occasion, your lordship, I have taken time for filing of an additional affidavit regarding that. I have filed an additional affidavit on 3/5/2024. 3/5 days. 3 days. So
When did you file?
On 3/5, my lord. 3rd May, my lord.
May. Have you given him a copy?
I'm giving. I'm just serving. So, my lord, this matter can be taken up also tomorrow. This also on the ground of limitation.
All right, we will take up tomorrow.
They do. I'm sorry.
There were 3 reasons. Who has already been dismissed on a lot of limitations. Your Lordship has already passed an order. I'm sorry, I got one copy of the order. Same matter, the all 3 are disposed of on the ground of Narendra Kumar suddenly. Now they have challenged that order to the Supreme Court now, Honorable Supreme Court.
Yes, we will follow it.
Hello. Yes, Mala, this is
follow it.
Yes, Mala.
I'm grateful.
Item 34.
Item 34, my lord, on behalf of Mr. Mahapatra, my lord, there's some personal difficulties, my lord, taken up tomorrow, my lord, or there.
My lord, tomorrow I am wrong, badly placed, my lord.
Tomorrow, as requested.
Item 35.
Oh, you are not available.
Mr. Patnaik?
My lord.
Tomorrow, if it is posted, then it will be all right.
Tomorrow, my lord, I am little inconvenienced, my lord. Can it be on Thursday, my lord?
Thursday. Monday.
All right.
Mr. Patnaik, it is Monday.
Okay.
Item 35.
Item 35 minutes. In this case, today I have filed my power minutes. If I need 2 weeks time to file objection to the
Application for coordination.
How much delay?
630.
No.
In the application, they have mentioned 690.
My what has happened, my lord, that my lord, after single just order, my lord, we have approached the Honorable Apex Court. Honorable Apex, without filing a writ appeal. Thereafter, your lordship may pay 78 of my writ appeal. That SL were disposed upon 28/8/2023, giving liberty to approach an inter. Lordship may pay 78. In view of the fact that the petitioner state has a remedy for filing an intra-court appeal against the impugned order, we declare to enter the is occurring, liberty is granted to the petitioner to assail the impugned order before the division for the in accordance with law. This was disposed upon 22/8/2023. Thereafter, my lord, we have filed it on 11/9/2023.
Yes, she's right.
It has been reflected at 693 days delay. Just filed a formal objection. It's a different lordship permit me, I have filed a formal objection. 600 because 693 delay has been pointed out.
1 week time is allowed for the respondent to file an objection to the application seeking condonation or delay. Is this case 1 week?
Item 36.
No, this is Sarat Parade. Sarat Parade, which my lord was hearing with the. That's
Sarat Parade.
Hemanta. Now Hemanta should try.
Who is for the other side?
Nobody has appeared.
Notices?
Probably notice on delay has not been issued.
Notice. Issue notice on invitation.
Item 37.
37 and 38 both my lord, work charge employees, notice and delay.
Notice
38.
on invitation.
Item 38.
37 and 38 are same.
Invitation.
Item 39.
39.
39.
Yes, ma'am. There is also delay. Notice. Limitation.
No, what is the matter?
The matter regarding that
Regularization
regularization.
of book charge.
Yes, ma'am. The Honorable Single Judge has held that as if he has worked for 30 years. So in fact, he was disengaged because of the reduction of work. Therefore, in 2014, he was engaged. So our case is that he was engaged in 2014. So he has not worked for 30 years. That is the only, but there is a huge delay, my lord.
Dismiss. How much?
This is the order passed on 26/8/2022. It is filed in 2024. Approximately
497 days.
The times.
497.
The present inter-court appeal is barred by limitation. There is a delay of 497 days in preparing the appeal. The matter relates to a regularization of work charge employee.
My lord.
Regularization of service of a work charge employee. From ID number and invitation. So after having perused the application, we are of the view that the explanation put forth for condonation or delay is not satisfactory. Also. The item number 39. IN number 385. 384.
I 385 of 2024.
Yes, following is the only explanation given in the application, paragraph 4. On top. IA number so and so. Accordingly dismissed. Consequently, the writ appeal also stands dismissed. Yes.
Item 40.
In item 40, my lord. Notice is. As it appears from my file on 6/4/2024, your lordship has issued on the question of limitation.
Someone has appeared.
No one has appeared.
Notices have been served.
Yes, ma'am.
Cannot be located and the author responded notice not.
Undelivered notice returned from respondent 2 with poster cannot be located. Then I will take fresh step.
Let first steps be taken for service of notice upon the respondents. Once 2 weeks. So we can go get them.
Sorry. Much.
Yes.
May I please? My lord, in line with the NLEP guidelines, I have prepared the pointers for your lordship's kind consideration for the petitioner. Your lordship.
Just may say one thing. Last occasion, the previous occasion, you also wanted the pointers to be given by the amicus curiae and to fix a guideline. So also you wanted that principal secretary should be present. Yes. Now I think you also will take up this matter so far as guidelines to be fixed, so that he is also there, can be carried out whether in collaboration with health, family welfare department or other department, so that it can be done today itself.
Yes, what do you want to say?
My lord, I have given the pointers as your lordship had desired. My humble request is that everything will start by ensuring proper health care, because that is at the core, your lordship. Your lordship will be monitoring it continuously. My only humble prayer is that the attention must be given initially to the health care. That's what it is. I have given the pointers how to monitor and effective implementation, your lordship.
So the aspects have been
My lord.
taken care of in the.
Yeah, Mike is my lord.
Yes.
Three of us have
The detailed one, the way it can be ensured effective implementation, I have made it in accordance with the guidelines that has been designed by the central government, your lordship.
These are the guidelines.
My lord.
Where are those guidelines?
Their guidelines is I have annexed to the additional affidavit I have filed. I can also pass on for my lord's kind consideration. There are two guidelines that have been issued. One is the program implementation plan, which I have enclosed with my additional affidavit dated 1st September 2023, your lordship.
What is there?
1st September 2023, additional affidavit that has been filed is on the records. So those two documents are the guiding documents, along with which the NLAP is to be carried out, your lordship. In pursuance to this, I have developed a data sheet. If that data sheet is followed, then the effective implementation can be ensured, your lordship. Given time, by next Monday, I will develop that.
Is there any program like eradication plan?
My lord.
So is it possible?
My lord, it is possible.
Eradication is possible.
My lord. Only if the NLEP is followed in its letter and spirit, and it has been done in other parts of the country, your lordship. All over the world, it has been done. Only in this state, somehow it has not been in the way. It should be done. Your lordship, if my lord grants me the permission, the requirement of the basic workforce, that is paramedical workers, has been highlighted by the government agencies from time to time. But there is a kind of peculiar resistance in recruiting those workforce, your lordship, who are very crucial. It has been admitted by them, by everybody.
Where is that NLEP?
My lord, NLEP is the document, and your lordship, the document I have filed, the additional affidavit dated 1st September 2023, your lordship. If your lordship can get that in hand, that would be, or else I can pass on
Just a minute, just a minute. Yes.
My lord. My lord, in that additional affidavit at page 145, Annexure 6, the government has clearly identified that lack of these paramedical workers is the single most important impediment in fulfilling the obligations or fulfilling the targets under National Leprosy Elimination Program, your lordship. They have clearly identified.
Just a minute, we have not seen page.
Page 145, your lordship, Annexure 6. To the additional affidavit filed on 1st September 2023.
No, that is for engagement of paramedical workers.
My lord, my lord. My lord, may kindly peruse if I'm allowed to place it, my lord.
Oh, that is one part.
My lord. My humble submission is the NLP program must begin with this because healthcare is the first thing, your lordship. Because in absence of this, the National Leprosy Elimination Program is a complete failure because of this. This has been identified here only. And
so, what is the qualification?
My lord, the subsequent pages, the very next page, your lordship, they had delineated everything. It is matriculation pass certificate, page number 146, your lordship.
And what is the fund, source of fund?
My lord, the fund is being allocated on this head, your lordship, continuously from 2011-12 against 404 posts. Your lordship may kindly turn to page. I have enclosed those documents that continuously funds are being provided, but somehow the people are not being engaged. Your lordship may kindly.
All right. So let us see.
My lord, in addition to this four.
Yes, secretary is here.
Yes, sir. Is there?
Yes. What is your response?
Sir, I am Principal Secretary, Social Security and Empowerment of Persons with Disability. As per the Honorable Court's direction, a monitoring committee has been constituted.
No.
And in this,
First of all, let us know what have you done for implementation of NLEP, and particularly regarding engagement of paramedical workers.
No, with regard to that paramedical, we have already filed an affidavit earlier, Milos. Because that was I'm not ready with that affidavit. I can place that affidavit. But the lawsuit had specifically today wanted to keep the guidelines for
No, for that, for preparing the guidelines, we may have to issue certain guidelines.
Right, Milos, right.
Therefore, we are trying to understand.
Yes. It comes under health department. It's not because it's health department. The health department is also not so involved in this project.
Part of the state level monitoring committee, lots of this paramedical workers, they all come under the health and family welfare department fund. So the SSCPD department is the nodal agency who is now implementing, my lord, the directions of this honorable court. A state level monitoring committee has been constituted.
State level monitoring committee has been constituted, must have been constituted only for the purpose of overseeing whether the provisions of the program are being implemented properly or not, and the persons are being taken care of properly or not. This is one. But if it has been rightly pointed out that it's primarily a health issue.
Yes, sir.
That will have to be addressed. So whosoever post he is holding, if he does not have any idea about the health department, what is being done for getting these paramedical workers, then what is the use of his presence?
sir, in fact, if I may submit that we have filed an affidavit, there are 3,218 male MPHW, this is a multi-purpose health worker. There are 7,224 multi-purpose health worker female. There are 865 MPHS male workers. Similarly, 755 MPHS female worker, 4,009 CHO, 48,000 ASA worker, 4,991 doctors who are MBBS, 1,385 Ayush medical officers, and 98 physiotherapists. They have all been trained in leprosy eradication and the program, and they are all involved. In fact, the number of leprosy cases have come down in Odisha from 10,000 to about 8,000 currently. And these programs are the multi-purpose health workers and the entire machinery. They not only look after leprosy, but all other the diseases at the wherever it is reported. And we have an elaborate program which we discuss in the monitoring committee, though it is the domain of the Health and Family Welfare Department. You may direct sir to the Health Secretary to come and brief you about the program. But as I understand, there is a comprehensive program which is taken up by the state government.
What is this your submission that these posts were only for the purpose of this NLEP?
My lord,
How do you say?
my lord, your lordship may kindly look at the affidavit, the same page that is at 145, your lordship.
147.
45, your
Up to
lordship.
147.
147, my lord. My lord. Submitting the criteria. In continuation to this
Yes,
direct.
Mr. Secretary, do you have these posts, leprosy, vacant posts of leprosy paramedical workers?
Okay.
May I request my health department?
Please,
joint
please,
director-
please, no issue. Please tell us.
Namaskar.
Have you engaged leprosy paramedical workers?
The paramedical workers now come down to 400 something. Now our other healthcare persons.
Mr. What is your name?
Dr. Khetraman Kand. Dr. Khetraman.
Kshetra Mohan. All right, Mr. Kshetramohan, please let us know. Under the NLEP, we are being made to understand that you are to engage leprosy paramedical workers. Have you engaged? Yes or no?
Yes, sir.
You have engaged. Should we record your statement?
Sir.
All right.
I think, my lord, if your lordship allows me, my lord, I'll assist your lordship, my lord. Lordship, the paramedical workers as envisaged in the NLEP program, my lord, state government has abolished all those posts. Now, the MPHW, those who are working in the hospital itself, my lord, they have been given this responsibility also to look after it. That is what affidavit has already been
Mr.
filed.
The NLEP envisages a dedicated workforce.
That's what, ma'am.
So
My
that is the
lawyer friend
reason.
has filed an affidavit.
And
with
he
regard to
says that they have engaged.
No, that is maybe wrong, but he's not understanding
Yes.
properly.
What he says, he probably has not got the question.
Understood, my lord.
His statement, probably, my Lord Justice Raman would also probably agree. He's not understood what is being deliberated. So that's why he said that we have engaged.
Our query he could not understand.
My Lord, if I can formulate this, my Lord, what Mr. Mishra for the PIL petitioner is trying to propose is, these posts have been abolished. It's a policy decision of the state. They have abolished this posts. The state government says that we have these multi-purpose health workers. They are good enough to look into.
See, the state government may take that decision.
My
But
lord.
is it permissible if there is NLEP and if the central government is providing you fund,
My Lord.
providing the state government fund,
My Lord.
they say that these posts leprosy paramedical workers should be there,
My Lord.
then is it open?
My Lord, that's a question which your lordships can formulate. Let the government give a pointed reply to that, because that is between the PIL petitioner and the government. So this question has not yet been specifically dealt with in the course of these proceedings. He's raising it. It's a point which needs to be answered.
इसको समझाइए.
Mr. Kshetra Mohan. Mr. Khati, perhaps you could not follow us. Is it your statement that dedicated persons are there for this leprosy health work? Have you engaged them? Or as Learned Council has said, that that posts have been abolished and multi-purpose health workers are engaged for that purpose, in addition to their normal duties.
Sir, multi-purpose health workers are engaged.
What is correct? What is true?
Multi-purpose health workers.
You have engaged them.
Sir.
They are not dedicated.
Sir, beside
Dedicated
that,
towards this leprosy program.
sir. Sir, beside that, ASA.
Please make a statement, sir. Please make a statement. Kindly understand. What have you done?
See, you have to say two things. Under the NLEP, I cannot be more clear than this. Under NLEP, is there any requirement to have a dedicated workforce of paramedical workers for leprosy patients? Is it correct or not? Is there any requirement under NLEP?
No, sir. We have so many multi-purpose workers.
Under the have you examined NLEP?
If I may submit, Dr. Kant is not thorough and is unable to present. What I was given to understand by the health secretary is that the number of cases are very less and not very frequently reported. And that is why they have trained a large number of people to detect the case, starting from the ASHA to health worker, both male and female. So they have made their presence almost universal, so that whenever a disease is detected, so that care is taken.
Possibly, it seems that we have failed to convey what we wanted to convey. Whether you are duty bound or whether the state government is required to implement NLEP or not. First question, yes or no?
Yes, sir, we are implementing, sir.
You are implementing. The second question is whether under the NLEP, paramedical workers for leprosy patients are to be engaged or not.
That large number of people have been engaged in addition to other duties, because the number of cases reported would be very far, and very few people all over the state. Only 8,000 people have been reported over such a large scale.
We have failed to convey.
This question can be best answered by the Health and Family Welfare Department.
At least this question, where is the any person answering this question? Anyone can answer this question.
My lord, may I please? My lord, in the year 2002, the government of Odisha took a decision to remove large section of this PMWs, your lordship, and decided to retain only 404 posts, your lordship. May I draw my lord's kind attention to page number 24 of the additional affidavit dated 1 September 2023. Page number 24 is the document by
So
which...
let us proceed point. The pointers have been submitted by jointly by the MSc Curie, Vibhu Prasad Tripathi, Gautam Mishra, Vibhu Prasad Tripathi, Gautam Mishra, and MS Pamira. To tackle to deal with the treatment, rehabilitation, and other aspects of leprosy patients in the state of Odisha, which include colon dash 1. Regular visits by the staff of concerned district welfare officers, welfare officers to the respective colonies in the district. 2. Regular visits by the medical team. 3. Monitoring of livelihood and skill development projects, not only of the leprosy and affected persons, but also their families. 4. Cleaning, sanitation in respective colonies where the leprosy affected persons reside. 5. Follow up regarding the issues relating to surgery, implants, distribution of what is MCR?
Medicated shoes.
MCR footwear, wheelchairs and other ancillary items. 6. Housing infrastructure. A follow-up regarding issues relating to repair of houses, toilets, and pathways in the colonies where the leprosy affected people reside. Stop. Next, they have also pointed out, they have also suggested that the state should take steps to resolve issues relating to lands for such colonies in a time-bound manner, wherever any such disputes exist. Stop. Particular reference has been made to the railway lands, and it has been suggested that the state may take steps involving Indian Railways. Stop. Next. It has also been pointed out that with this court's intervention and monitoring, what is Balasore Leprosy Colony?
The name of the colony is Louis Leprosy Colony, Balesore.
Louis Leprosy Colony, Balasore has reached a satisfactory level. Which model should be replicated in other colonies also? LEWIS, Levis.
Yes, there in that note, last line, LEWIS.
Yeah. Full stop. Next. Learned counsel appearing on behalf of the petitioner has submitted that health of leprosy affected persons should be the core issue which should be addressed by the authorities Person is of paramount importance, which should be addressed on priority basis. Stop. The court's attention has been drawn to National Leprosy Eradication Program, bracketed NLEP, of the central government. Of the central government. Stop. It has been pointed out that the said NLEP inter alia requires engagement of paramedical workers for effective implementation of the NLEP. Stop. He has argued that there is no dedicated workforce in the nature of paramedical workers, bracketed PMWs, for NLEP. Stop. Who is present? What is it?
Secretary SSEPD.
Secretary.
SSEPD.
Principal Secretary.
Principal Secretary. Full name.
Social Security and Empowerment of Physically.
Has joined online. Stop. Next. Before we proceed further in the present matter, we would like to have clarity on the point as to whether the NLEP as framed by the central government is to be central government has been decided to be implemented in the state of Odisha or not, and whether the said program is being implemented or not. So stop. In response to the queries made by this court as to whether dedicated paramedical workers have been engaged or not, the principal secretary, and who is with you? The health department?
Secretary.
And
No,
the secretary.
He not the secretary. Secretary is somebody else now.
Secretary, principal secretary has informed that paramedical workers and ASA workers have been engaged throughout the state of Odisha.
That is said by Lord, multi-purpose health workers and ASA workers.
Multi-purpose health workers and ASA workers have been engaged throughout the state of Odisha, who look after, who take care of the requirements of leprosy affected persons also. So stop. Next, we will take up the present matter again on 21st at 2 p.m. So stop. The
21st.
21st.
No, at 2 p.m.
So
20th.
Last working day.
Last working day, Malord.
Lordship may be invited by the bar.
All right, 20th.
20th.
Maybe 20th.
20th, let us do it before
Yes.
summer vacation
Kindly
begins.
keep it on 17th.
17th, we can do 17th, probably it may be difficult for them to address all these issues. Though our questions are very basic, fundamental,
Yes.
just we were trying to understand.
Yes.
And then only what I would suggest, subject to that if NLEP is there and it is to be implemented, then whatever is there, that will have to be implemented. This is one aspect. And the second is that if the state can do more than what is there in the, then it's good.
NLP only confines to the medical aspect of the matter.
So therefore, that is the minimum
Minimum.
which they'll have to implement.
This one thing, Your Lordships, NLP comes out with revised guidelines almost every year.
All right.
Yes. And one of these guidelines, which of course I had a copy, I'm not missing out, was a guideline where there was a strict instructions not to segregate. So that guideline also to come, because I think this, unless we don't look at every guideline, we don't get the spirit of the matter that why they have abolished the post. So that is something, because I had read that very carefully. Because that was in fact our first question when we visited. Because what we did is we went to the respective hospitals and the CBO and asked that why are you not sending them a dedicated person? And then we went back and we saw these guidelines also. So there was because the whole idea of segregating them and giving them a separate treatment. So that is exactly what NLP in one of its guidelines has said to stop that practice. So even that guideline.
No, segregation, see, that has a different purpose. That requires specialized training.
Lordships. That is why they gave the specialized training to the existing workers, and in fact, in all these small nearby health centers, there will be a physiotherapist. We all had been there and seen it.
All right.
So I mean, I need to
We will
say
see.
that- Yes.
This is what is also there in Pankaj Srivastava case. The direction in Pankaj Srivastava case is this in a healthcare to leprosy patients at both government as well as private or medical institution must be such that the medical officials and representatives desist from any kind of discriminatory behavior while examining and treating leprosy patients. Treatment of leprosy patients should be integrated into general health care, which will assure in a no isolation method in a general ward and OPD services.
So that is different.
My lord, your lordship is asking only about a dedicated person.
Yes, dedicated person, specialized training.
Yes, madam.
And dedicated for that group.
Right.
They require special attention. This must be the purpose. It is not that by having a different cadre, they are segregating the patients. But it is for the purpose of specialized attention.
Well, the guideline specifically says these PMWs will be working within the general healthcare system. So no segregation. But since these patients need a special kind of attention and treatment, so these PMWs have to be operating.
At 2 p.m. So stop. In the meanwhile, we expect the state opposite parties to come out with, will they come out with proposed scheme to be disclosed to this court so as to facilitate this court passing appropriate orders in the present public interest litigation, addressing all the pointers as have been noted here and above. Stop. In addition, the state respondents, opposite parties, shall be required to inform this court as to whether there is requirement of dedicated paramedical workers for implementation of the program or not under the
NLEP.
Workers for leprosy affected persons for implementation of NLEP or not. Who is for the central government?
Yes, my lord, I am.
What is your stand?
Yes.
You are the best person to tell us.
Yes, my lord, your lordship is not directing for a.
Lordship will not direct you. This is your program.
Yes, my lord. They are implementing this one.
You are happy?
No, my lord.
All right, we'll take.
Every date I am presenting, my lord.
Huh?
Every date I am there, my lord. But your lordship is.
Even if you disappear, we don't have any issue.
One thing can be said that the central government is interested.
Your appearance is not enough.
No, my lord. I am there, my lord. But your lordship is addressing them. So.
No, you don't owe any responsibility.
Yes, my lord.
To
I
inform
have the
the court
responsibility.
that certain progress have been made by collective efforts of your
And
brethren.
they are constituting the committee, but ignoring us, my lord. What can we do, my lord?
See,
They are constituting
you
committee,
should
but
always bring
ignoring
more
us.
involvement.
All right, we are not ignoring you. Tell us. Tell us what you want.
I will file affidavit to that regard, my lord. Whether the scheme is implemented or not, properly implemented or not.
See, though your NLEP was of 2011.
Yes, ma'am.
Is 2011? 2012. This writ petition was filed in 2015.
Yes.
You have not filed even single affidavit.
I will file my.
No, because you know that you have an agency through the High Court to implement your program.
No, my lord.
So it's very bad.
That is not, my. Absolutely not.
If your lordship allows, he should be actually behind the state government because they have.
And you have a grievance that you are being ignored.
They have.
Yes, my lord. Actually, we are ignored, my lord. In fact, my lord, with great anguish, I am submitting this.
So should we record that?
Yeah.
Please make your statement with some sense of responsibility.
We will file affidavit.
Don't do anything.
Yes, ma'am.
Yes.
Obliged.
Great.
Anything else?
No.
This is how I.
Yes, yes. We are grateful to you.
Whether are we misdirected? No.
No. These once this clarification comes in, then we'll be able to implement all this in a smooth way.
And in addition, what the state government is doing, state government shall keep on.
There are different schemes of the state government also. Apart from the NLEP, there are different schemes of the state government.
Yes, sorry, Maharaj, that MCR is actually microcellular rubber.
On these aspects,
there are two kinds of footwear. One is MCR grade 1 and grade 2. Grade 1 is for the lesser affected people. Grade 2 is for people having those huge problems. So they are specially ordered and made. So that footwear is something very essential for these people. So that's microcellular rubber.
From Rajasthan or something?
No, they order it. I think
they
centralized.
have a place also.
No, my lord, the guideline is there that
Nirtar is there.
Nirtar
is nearby. 60 kilometers far.
Not 60 kilometers, even 40 kilometers.
So this MCR grade 2 is something which is difficult to get. Grade 1 usually they can give it everywhere. But it's grade 2 which needs to be specially ordered for each person.
No, they have each stage of their
element.
Yes.
So
my lord, within NLEP, there is provision how these things have to be tackled. By the next date, it would be clear, I think. Many things would be clear. The central government being sensitive, apart from the paramedical workers existing in the state, has given funds and sanctioned 184 additional posts. That is also not being filled. because Odisha is one of the high density.
See, we are not about filling up of the.
No, no,
posts.
just
We are about
healthcare.
implementation of the program in accordance with the program.
My lord.
And MCR I have not been able to.
MCR is microcellular rubber. That's the full form of MCR.
MCR
Microcellular rubber.
So there's a consistent issue that we have heard from the inmates is that they hardly last. So the quality is something we also need to work on. They hardly last. One or two of washes they.
Have you mentioned that in your report?
Earlier reports they are there.
We have written there, my lord, with regard to supply of MCR shoes is also a pointer, my lord, which is there.
On the quality aspects, the previous reports are there. Because the monitoring meeting which happens, so according to the directions of the court, Mr. Tripathi and myself also attend that meeting. So we normally raise the issues there as well.
And the SSPD department secretary is very proactive, my lord, in taking up these issues. He has recently joined, but he is taking up those issues in the.
Mr. The one who has joined.
Yes, my lord. He has recently joined, but he is taking up these issues and every now and then the meetings
the
are.
meeting which happens as part of the court, these Mr. Tripathi and myself also attend those meetings.
What is your name, Mr.? What is his name?
Vishnupada Sethi, my lord.
Mr. Sethi, don't get discouraged by any observation which we make in the court proceeding. So we are happy that you are being proactive. Sometimes we make observations. So that should not discourage you. Thank you.
We are all grateful to you.
So may we favor with a order for losses.
Yes, you will get it.
Done
Yes.
earlier, my lord, so that I can contact them.
Almost every orders are uploaded.
No,
nowadays.
I
If
can
there is any
copy
problem, you just come.
You will get it.
Come. More potential.
You will get it.
Upload he not.
It will be uploaded. You order
I'll check. Lordship, I have made
61.
some date charts and Lordship.
Item 61.
Yes.
Respect kindly WPC 34769 of 2020, which was a lead case. If my non-friend wants to argue his case separately, let him do. We have nothing to say. Let him complete, my lord. Then we'll have our say. It will take some time.
How much time will it take?
Lordship, only half an hour.
Half an hour.
Lordship.
What about them?
Lordship,
all right.
So to make it short, Lordship, I have given the.
So just 1 second, slide. So can I take leave from your lordship, lord? We'll let him complete. We'll come after some other matters.
I've given the.
Or you also so our matters are concerned of segregated. Otherwise, it will unnecessary. Our argument is totally different. He said that he's challenging something else.
So once we decide similar matter in his case, then
that is the problem. That is why we want that only one party.
so we will be bound by our own order.
All right, let him argue. Let him argue.
Let him argue.
Let everything, the entire, all the cases be jointly say that. Let him argue thereafter.
So that we can.
Lordship, second page is the dates and events I have given.
Your matter is 24237.
Lordship, first item. Piripa Degree College at Post Input District Kendrapada was established in the year 1982. The said college received government concurrence and appellation with effect from session 88-89 and became eligible in terms of clause 7.4 of the Granting Aid Order 1994 as defined under.
Just a minute, don't read it. Refer to the provisions side by side.
Lordship, this is fact I have given.
Mr. Counsel, you have mentioned in terms of clause 7.4.
Lordship.
I don't know what is clause 7.4.
Lordship. Lordship, kindly come to new book.
Clause,
Page
which page?
137, Lordship.
Four is at 133.
Clause 7(4) in granting at order 1994, Lordship.
Just a minute.
Starting from page 5, 4, 5.
This clause 7(4) of granting a
Net
order, where is that?
1994, it is, Lordship, at page 552.
Yes.
After completion of his inquiry, the director shall report to the state government the fact and circumstances in which the applicant institution has been found eligible or not eligible, and shall also make a recommendation in this respect of each applicant. Lordship, this is what this recommendation shall be made for getting antenatal, Lordship. Then, Lordship, 3B, as I mentioned there, 3B of the Odisha Education Act.
Where is that? Yes, 3B.
3B of the Odisha Education Act. Lordship.
Yes, tell us.
3B.
Yes.
Aided educational institutions means private educational institution which is eligible to and is receiving granting from the state government and includes an educational institution which has been notified by the state government to receive granting aid.
And what is this affiliation?
Affiliation, Lordships, government gets, college gets affiliation, thereafter granting recognition, thereafter granting.
What is this affiliation with what? Affiliation, whenever this word is used, affiliation,
Lordship,
there must be something affiliated with or affiliation with. Affiliation with what?
With the college. Affiliation of the college.
Affiliation of the college with what?
Let's see, that is at section.
Or affiliation to what?
To the institution by the authority.
So we decline to hear you. We will not hear you.
Lordship.
It is impossible for us. Yes.
Lordship.
We will hear you later. It is impossible for us. Yes. Whenever you use a word, you should know in what context that has been used. You are saying affiliation, you don't know what is affiliation. You are saying affiliation, you don't know affiliation to what. When we are putting question, you say affiliation institution. What is this? And you want to lead the argument.
That's that can
We will take up your case as the last case.
Lordship, then.
Sorry. Yes.
Lordship rightly put that question. But a college, in order to establish a college under the Odisha Education Act,
initially the permission has to be taken on section 5, permission. After getting permission, then permission is a precondition to make an application for recognitions. Section 5 is permission. Section 6 is the recognition. Then question of affiliation comes. A university or council, they used to give affiliation only after the college institution get recognition. Affiliation is a concept under the University Act, read with the Orissa Education Act, that unless a college or institution is affiliated to the university or council, their students cannot be permitted to appear the examination. That is the concept of affiliations. If I'm correct, I'll show.
Yes, that is it.
Now, let's kindly see, before let's kindly come to section 7. Section 7, subsection C. Because I had placed before lordships different provisions, but I want to confine the very provision after. Yes.
Yes.
Section 7C. This was incorporated by Orissa Act 14 of 1993.
Yes.
Yes, sir. I'm just reading two paragraphs. Section 7C1, granting aid. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for being given as granting aid to private educational institutions in the state. Then 2, no order according permission or approval or recognition under this act, whether prior to or after the commencement of Orissa Education Amendment Act 1994, shall entitle any private educational institution to receive granted aid. Then 3, save as otherwise provided, no private educational institution which has not been recognized by the state government under this act shall be entitled to receive any aid from the state government. Then 4, notwithstanding anything contained in any law. I'm reading it very slowly, the whole provisions, because your lordship was posing some question out of section 7C4. Notwithstanding anything contained in any law, rule, executive order, or any judgment, decree or order, any court, no granting aid shall be paid, and no payment towards salary cost or any other expense shall be made to any private educational institution or for any post or to any person employed in any such institution after the commencement of the Orissa Education Amendment Act 1994, except in accordance with an order or rule made under this act. Granting aid where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. Let us pause for a moment. Prior to this Amendment Act 14 of 1993 came into force, when the 7C4 was incorporated, the granting aid was regulated by principle of executive instruction. There was no statutory rules. For the first time, this act was enacted, where section 7C4 was incorporated, and pursuant to which the granting aid order is to be framed, and on that basis, granting aid will be released. And on the basis of this, 94 granting aid order was released. That is page 545. Page 545. The lordship's book, Orissa Non-Government College, Junior College and Higher Secondary Schools Granting Aid Order 1994.
Yes.
Lordship, see the preamble. In exercise of the power conferred by subsection 4 of section 7C of the Orissa Education Act, the state government do hereby make the following order to regulate payment of granting aid to private educational institution or for any post or to any person employed in such institution, being a non-government college, junior college, or higher secondary school as specified hereunder. I just, in the preamble, you'll also kindly find that granting aid to private educational institution, comma, or
this has been repealed.
This has been repealed. This has been repealed. That is subject matter plus. that this 94 granted in respect of a post, any person employed to such institution, being a non-government college, junior college, higher secondary school, as specified hereunder. So therefore, the exhaustive provisions have been provided. Rule 9, I just, last time I was placing that, I did not, I'll place it later on. But at this juncture, may I take your lordship to section 24B? Page 159 of the Orissa Education Act. Act is a substantive term, 159. But 7C4 was incorporated by Act 14 of 93, and this section 24B was incorporated by Act 5 of 98. That is on 7th April 1998.
You are referring to 24?
24 capital B.
Capital B.
Yes, sir. Fine,
Yeah.
it's obligated.
Yeah.
Yes, sir. Adjudication by the tribunal. The tribunal shall have jurisdiction, power and authority to adjudicate all disputes and differences between the managing committee, as the case may be, the governing body of any private educational institution, and any teacher or employee of such institution, or the state government, or any officer or authority of the state government relating to or connected with the eligibility, entitlement, payment or non-payment of granted. Am I clear? So this was the power was conferred on the Orissa Education Tribunal to adjudicate all dispute in connection with the eligibility, entitlement, payment or non-payment of granted. And there is a provision of section 24C of appeal. There is a provision of appeal. If you also we look to 24C, appeal to High Court. Any person,
Yes.
any person aggrieved by an order or decision or judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order or decision of the judgment. So this is the substantive provision which was incorporated under the Orissa Education Act, section 24B, read with section 24C, for adjudication any matter relating to the dispute in connection with the granting to the employees. Now at this juncture, may I take your lordship to my brief, a short date chart I have given, and I see that what was my I had given to your lordships. I think it is available in the brief. In the WPC 34769 of 2020, and this matter was in fact hard by lordship predecessor, but because of it could not be complete. Just I'm taking to lordship that date chart, some dates, not all. Tikke bahar kar do.
Mr. Vishal, what is the number?
WPC number 34769 of 2020.
34769
of 2020. My lord.
Order page. This is lead case. We also look to that the order of the coordinate bench, order number 8 dated 17/8/2023. This matter was taken up as a lead case. The matter was heard substantially as this is a lead case amongst the analogous matters. Let's get it at order number 8 dated 17/8/2023 in WPC number 34769 of 2020.
Yes.
And I have given a date chart in that case, which will also be referring to the last occasion. Kindly, sir, date chart. Kindly. Yes. And I have also formulated certain points. Yes. Very good. We'll also look to the date of events. Why I'm saying so. In fact, my appointment is 1990. We'll also see that serial number 2. Present petitioner's appointment. And the college came to the fold of granting it order 90. This 94 granting order came into force on 1694, serial number 3. And a proposal was submitted in my favor, in our favor, by the college in terms of the 94 granted order in 95. First, we look to that serial number 4. I don't want to place to take your lordship's time, much time. 95, a proposal was submitted by the governing body to the Director of Higher Education, who is the prescribed authority, for releasing the grantee in terms of 94 grantee order. As the petitioner has fully satisfied the criteria under 94 grantee order, read with section 7C4 of the Orissa Education Act, it is learned that though the proposal was submitted by the college in time, there was delay at the level of the director to release the grantee rate under 94 grantee order. 8396, on 8396, in exercise of the power conferred under section 3B of the Orissa Education Act, read with paragraph 7.5 of the Orissa Non-Government College, Junior College, Higher Secondary School Grantee Rate Order 94, the petitioner institution being a category 2 college as per paragraph 4 of the Grantee Order 94 was declared as an aided educational institution with effect from 1694. My institution was declared to be aided educational institution in terms of section 3B, because 3B definition of aided college, that was on 8/3/1996. Proposal has been submitted in my favor in terms of 94 grantee rate order. While that was pending, my college was notified to receive the grantee rate order in terms of 94 grantee rate order. Then, sir, 96, 19/3/96, serial number 6. In terms of the grantee rate order 94, approval was accorded to some of the teaching and non-teaching staff of the institution for release of direct payment of salary cost with effect from 1694. Some of the staff who were appointed along with me, proposal was submitted along with me, the grantee rate was released in their favor under 94 grantee rate order. Then 96, as and when the case of the petitioner was not considered for approval of appointment and release of grantee rate in terms of 94 grantee rate order, the present petitioner approached this honorable court by filing a writ application bearing OJC number 14057/96. That's a kindly have a mark. This is 96. I had approached this honorable court. Then in the meantime, while the matter was pending, on 7/4/98, Orissa Education Act was amended by virtue of the amendment of 5 of 98, and section 24 capital B was incorporated, which just now I placed before your lordship, thereby conferring power upon the tribunal to adjudicate the dispute relating to or connected with eligibility, entitlement, payment or non-payment of grantee rate. That is at 159 page. Then 5/2/2004, that repeal provision, which is the subject matter challenge, while the proposal was pending in terms of grantee order 94 before the OP number 1, and the matter was pending before this honorable court, the state government, in exercise of the power under subsection 4 of section 7C of the Orissa Education Act, promulgated a new grantee rate order, namely Orissa Non-Government College, Junior College and Higher Secondary School Grantee Rate Order 2004. And by virtue of the said order, Rule 4 of 94 grantee rate order was repealed, and grantee rate already released under grantee rate 1994 was protected in the repeal order. That means the person, those who have got the grantee rate under 94, they are protected. Those who have not got, even that is pending for adjudication under section 24B, that was not protected under that section 4 of that 2004 grantee rate order. Then 2008, the Orissa Non-Government College, Junior College and Higher Secondary Grantee Rate Order 2008 came into force. Accordingly, 2004 grantee rate order was also repealed. Then 6/6/2009, another grantee rate order, namely Orissa Aided College and Aided Junior College, Higher Secondary School Grantee Rate Order 2009 came into force. Then 23/2/2010, in terms of Orissa Aided College, Junior College and Aided Higher Secondary School Grantee Rate Order 2009, the appointment of the petitioner was approved as a lecturer in logic with effect from 1/2/2009. Pause for a moment, sir. So far as my colleagues or persons, those are appointed along with me.
But are you putting to challenge this 2004?
Right, sir. Right. I'm challenging the repealing provision of 2004. That is why I'm bringing to lordship's notice the history.
2020.
Sir, why I'm challenging it, lordship kindly see. Next is 9/1/2014. The OJC of 96, 14057 of 96, preferred by the present petitioner, was transferred to the State Education Tribunal by the Honorable Court and was renumbered as GIA case number 38 of 2014 in view of the enactment of section 24B of the Orissa Education Act, conferring power upon the State Education Tribunal for adjudication of all matter relating to grantee rate. Then 1/2/2018, this Honorable Court transferred the matter to the tribunal in terms of section 24B because the adjudication has to be made by the tribunal. Then on 1/2/2018, the Learned Tribunal by order dated 1/2/2018 allowed the GI application preferred by the present petitioner by setting aside the order dated 23/2010 and further directed the OP number 1 and 2 to approve the appointment of the petitioner under the granted order 94 and release the granted, that is 1/3 from 1694, 2/3 from 1696. That's then on 21/1/2020, against this order, the state government filed the review application. Review application was also dismissed by the tribunal. Then in 2020, they filed the appeal under section 24C because that is a provision of appeal. And in appeal, they have taken the only stand because of a judgment of the Honorable Apex Court in Anup Senapati's case. I'll cite that judgment. And at this juncture, we had no other alternative except to approach your lordships, challenging that virus. And at this juncture, yes, your lordship may kindly come to, I have formulated certain points for your lordship, sir. How far I can convince your lordship, I don't know, because there are some judgments of this court, which of course by the Honorable Apex Court also, which has not been taken note of. I'll cite to your lordship, provided your lordship have today's time.
Just enough time.
Yes, sir. Sir, I have formulated certain points. I've given to your lordships. Already I've given. Yeah, I do. Already arguments. This one. Point 2 pages only. That 1.5 pages. Already scanned. It has been scanned. I think it has been scanned already. Then I would have put it in there. Sorry. I think I'm not consuming lots of time. Let's kindly have a glance. I'll carry it.
Yes.
Whether pursuant to section 7C of subsection 4 of the Orissa Education Act 1969, read with the provision provided under the Orissa Non-Government College Junior Higher Secondary Schools granted under 94, the right which has already been accrued in terms of the aforesaid statute in favor of the petitioner, can the same be annulled by repealing the provision under Rule 4 of the Orissa Non-Government College Junior College and Higher Secondary granted under 2004? Then second, whether there is a reasonable nexus with the object sought to be achieved by repealing the 94 granted order. Then 3, whether by virtue of the repealing the provision of 94 granted order, an artificial classification has been made out of the same class of the employee, which will lead to gross discrimination as envisaged and guaranteed under Article 14 and 16 of the Constitution. Then 4, whether the judgment rendered in the case of State of Orissa versus Anup Kumar Senapati and others, reported in 2019, volume 19, SCC, page 626, can be applied to the present facts and circumstances of the case, where the virus of the Rule 4 of the granted order 2004 is the very subject matter of challenge. Then 5, whether the right of the petitioner prior to repeal of the 94 granted order, who have approached the competent court of law and their right has been declared in terms of the granted order 94, can the judgment of the competent court or tribunal be nullified by virtue of the impugned Rule 4 of the granted order 2004? 6, whether if the teaching and non-teaching staff who are covered under the Orissa Educational Institution Appointment of Lecturers Act 1998, because there are 3 more judgments where referring to this act, the 94 granted order has been protected and direction has been made to release the granted, and are held to be entitled for approval of their appointment in terms of the 94 granted order, even after the said order 94 has been repealed. Can the petitioner who stand on the better footing can be treated as a separate class from the class of employees whose service were validated as per the Validation Act 1998 within the meaning of Article 14 and 16 of the Constitution of India? Whether even after repeal of the 94 granted order by virtue of Rule 4 of the granted order 2004, the benefit of 94 granted order has been extended to the person similarly situated as that of the present petitioner, even after the pronouncement of the repealing order 2004 granted order came into force. But that means after the judgment was pronounced in that Anup Senapati's case, they have extended the benefit. And despite the provision of repealing provision 2004, they have extended the benefit in 2000 under 94 granted to other employees under in 2019 and 20. Now you also kindly look, there are some. This judgment, of course, where this issue was raised. Yes.
In fact, on the last date also, we had observed.
Yes, sir.
That if we hold that provision ultra vires.
Your Lordship is asking that question to me, that if the Lordship will ultimately come to a conclusion that Rule 4 is ultra vires, then the judgment passed by this Honorable Supreme Court will not be given effect to, it cannot be. Whether your Lordship can or not, that I can address your Lordship. So therefore, what I am proposing, because this is a matter I must, because there is a far-reaching consequence, subject to your Lordship's acceptance. If your Lordship, because there's holidays coming on, many matters are there. So therefore, I want also some time for your Lordship, at least to address your Lordship and talk. And a full bench judgment has been delivered in this case. I've enclosed that. Possibly my learned friend must have. So look to, I'm just taking to your Lordship. This is that Union of India. So this is not like this. Prafulla Kumar Sahu versus State of Orissa. This judgment was upheld by the Supreme Court. If your Lordship will turn to, the very object was that they have made a resolution at that time, saying that because of the financial crunch, we are not in a position to release the grant under 94 granted order. Therefore, your Lordship, looking to Section 7C4, it is not within the economic capacity of the state. Therefore, we cannot release the grant in it. We will only release the block grant. That was the subject matter of challenge in the Prafulla Sahu's case. And the Prafulla Sahu's case, it was allowed with a finding, that judgment I have given, and that was upheld by the Supreme Court. And that was, the finding was, once you made a substantive provision under Section 7C4, you have to make a provision in the budget, because education is a subject that is like also health. You must give preference, and I'll place that judgment. If your Lordship, I'll take some time to place that judgment. If your Lordship will come, I have page marked. Page 14, your Lordship, in ink I page. This judgment was upheld by the Supreme Court when? In 2011. This was 2010, after the repeal provision was made. And I'll show your Lordship the only ground which was taken before the Honorable Appeals Court, because the 94 granted order is no more there. It has been repealed from 2004. Therefore, this civil appeal has to be allowed. But the civil appeal at page 14, we have carefully gone through the impugned judgment passed by the division bench of the High Court. In our considered view, no interference is called for. We, however, direct the appellant to exercise the case of the respondent as expeditiously as possible in any event within 4 months from the date of the order. And this judgment, you also look to the next page 15. That is very important, where this question was raised. A division bench, of course, a coordinate bench of this court. At page 15, 39 colleges, they had approached this honorable court despite the provision of that repeal provisions. And the judgment was delivered on that 12/1/2011, Chitaranjan Mahapatra versus State of Orissa, disposed of on 12/1/2011. If your Lordship will look to, straightway go to page 20, where the repeal provision has been considered. Page 22. Yes, sorry.
Yes.
Yes, sir. You will also look to para 12. Para 12. In para 12 at page 18. In subsection 4 of section 7C of the Orissa Education Act, however, it is clear stated that granting aid where admissible under the rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. We have perused the provision of the granting aid order 1994, and we do not find therein any mention as to the date from which the granting aid would be payable. Clause 16 of the granting aid order 94, on which Great reliance was placed by Mr. Swain in support of his submission that granting aid would become payable as soon as the eligibility of granted decided by the director. Then 16, this has been quoted from Proposal House case. On receipt of the proposal from the government governing body under para 15, the director shall examine each case, and if he is satisfied that the persons proposed by the governing body is eligible to receive granting aid against an approved post, he shall make an order to that effect. Where the director is satisfied that a person proposed by the governing body is not eligible to receive granting aid, his decision shall be communicated to the governing body. For the purpose of satisfying him as the eligibility of a person to receive the granting aid, the director may call for any information, clarification, or document that he consider necessary. Then that paragraph 16 or so skip over. Then kindly come to para 15. Orissa is a state with large section of people, including scheduled caste and scheduled tribes, who are illiterate and backward, consistent with the directive principle of the state policy in Article 41 and 46 of the Constitution. The legislature has imposed a mandate on the state government under subsection 1 of section 7C of the Orissa Education Act to set apart a sum of money annually for being given as granting aid to private educational institutions in the state, subject to the limits of economic capacity. The state government has also made the granting aid order 94 under subsection 4 of section 7C of the Orissa Education Act, clearly indicating the relevant factor to be taken into consideration for deciding the eligibility of an educational institution or a member of teaching and non-teaching staff of such educational institution, keeping in mind the educational need of the state. The state government cannot ignore such legislative mandate, as well as the directive principle of the state policy, the statutory provision of the Granting Order 94. Unless, therefore, there are other more pressing needs than education, the state government must set apart sufficient money for making payment of granting aid to educational institutions or their teaching and non-teaching staff in accordance with the Granting Order 94. For the aforesaid reason, the impugned order is quashed, and Director as well as the Secretary of the Department of Higher Education, Government of Orissa, are directed to reconsider the case of the petitioner for approval in the post of junior librarian and eligibility of admissibility granting aid, and the post strictly in accordance with the Granting Aid Order 94, and the observation and the judgment within a period of 4 months. Then you also may kindly come to the paragraph 6. Coming back to the facts of this case, that Chittaranjan's case, we refer to the office order dated 29th November 2003 passed by the Commissioner Secretary to Government Department of Higher Education. The relevant portion is read as follows. Chittaranjan Mahapatra and others, about 40 colleges at present working as teaching and non-teaching staff of so-and-so colleges. The Director of Higher Education has submitted a proposal to the government by notification dated so-and-so to notify the +2 weeks of so-and-so college as an aided college under Section 3B of the Orissa Education Act, and to sanction granted aid in favor of the eligibility employees of the college. At present, proposal in respect of 39 +2 unaided colleges are pending at government level for consideration due to resource crunch faced by the state government. In the aforesaid, it is crystal clear that the proposal for consideration of granting aid under 94 for the college of the petitioner as well as 38 number of +2 unaided college was pending before the government, and no decision was taken solely on the ground of financial crunch, for which this court decided in the case of Prafulla Kumar Sahu Supra, negativing the plea taken by the government. So after the judgment, the Honorable Apex Court passed the civil appeal number so-and-so. Nothing survived for decision in the present case. However, so far as it relates to the virus of the notification, dated 5th February 2004, Granted Order 2004 under Annexure 9, non-council for the state furnishes the list of 39 +2 colleges as indicated below. All these 39 colleges that was quoted at page 22, whose cases were considered and found to be eligible for release of granted aid in terms of the Granted Order 94, but the granting aid could not be given due to the reason for financial crunch as described by the state authority, the dispute over which has already been set at rest by the Honorable Apex Court. In view of such, we dispose of the writ application. This was disposed of in 2010. In terms 2014, I think. This was disposed of on 2011. We disposed of the writ application in terms of the decision of Prafulla Kumar Sahu versus so-and-so and Chittaranjan Mahapatra versus so-and-so, and directed the state government to examine the eligibility of each of the petitioner and release the grantee aid in their favor strictly in accordance with the grant rate order 94. The differential salary as well as the area, if any, shall be paid to them. The entire exercise shall be completed within a period of 4 months from the date of communication of the order. In terms of the judgment passed in Chittaranjan case and this case, 214 degree colleges and 39 plus 1, 42 plus 2, 41 plus 2 colleges, they were released the grantee aid in terms of 1994 after the repeal provision was made in 2004. And then the next is the full bench judgment of this court. There the question again comes whether the judgment passed in Profullus House case is correctly decided or not. That is at page 23. You're saying?
No, but again the question is
Sure.
that because of that Anup Kumar Senapati, suppose had the matter been before the Supreme Court, whether bench strength same of fee two judges.
I understand what your lordship wants to say.
Very difficult.
Yes. So if this judgment could have been placed in Anup Senapati's case, whether this is a division bench judgment, that is, the position could have been something
not
different.
Only that, suppose the virus of the provision which you are challenging here, had that been under challenge in Supreme Court.
Can I? But your lordship's power on Article 226.
No. Again, the matter would have been required to be referred to
But in fact, what has happened, a batch of cases have been posted before the Honorable Supreme Court, particularly relating to the matter where also this question is raised. Therefore, I was making a request, your lordship, because that matter is likely to be disposed of, because that was posted on 10th. I don't know what has happened. The matter is likely to be listed immediately after vacation. I was told by the council. Same, a batch of cases. Similar, this question was also raised.
No, let us decide this. Otherwise, so many matters are pending.
Right.
Let us decide this before the Supreme Court decides that.
Right, sir. So
that is the
right. You are
very
that
tricky
question,
situation.
That I put that question to myself also after your lordship posed that question to myself. If suppose that particular judgment has not been referred to by the Honorable Apex Court, and the Honorable Apex Court Anup Senapati judgment is based on the repeal provisions. The repeal provision, as your lordship rightly said, repeal provision was not the subject matter of challenge.
Right.
So now, had it been challenged, position would have been different. But since it is a virus of a particular rule, and your lordship is otherwise also is competent to decide the matter this way or that way.
No difficulty in entertaining the challenge. But difficulty is that it will take out the very basis of the Supreme Court's decision in case of.
The question is, if suppose your lordship will come to a conclusion that the rule 4, there are 2-3 points. Rule 4, in fact, is unconstitutional or ultra vires. Your lordship is right in saying the effect of the judgment of the Supreme Court will be lost. So whether your lordship can or not. I am prepared with that. Lordship, keep it. I'll answer to your lordship those judgments. And more, why it is disturbing to us, Lord, 214 colleges, degree colleges, 41 colleges, after the repeal provision, the grantee aid was released, and I have enclosed those judgments also in 2019.
Maybe the what you are seeking you may get, but not here.
But power under Article 226.
Power we are aware of.
Power under Article 2. I'll address the lordship on that point also, particularly.
So let us decide. And if you have any other decision, you can give.
Yes. And in fact, this full bench judgment has come in 2014. And on the basis of the full bench judgment, large number of institutions have been allowed to receive the 94 grantee order. And now they are adopting a pick and choose method. They have refused because of the Anup Senapati's case. And the very same matter has gone to Supreme Court and they have lost it on the ground that this very repealing provision they have cited, but that has not been accepted, and I have given those judgments. And they extended that benefit in 2020.
All right.
Yes.
Yes. Why is this happening that you are extending the benefit to some and denying to others?
Judgments of this court were parent or of this court, and naturally after result we had to pay. But again,
But not on your own.
no, not on. Because we have lost in the non-organic court and we have.
But the 214 colleges and plus 31 junior colleges, they have not gone to Supreme Court. They have implemented the judgment of this court.
Before Anup Senapati.
That is before Anup Senapati. Even after Anup Senapati, I am giving those copies also. Let us see. They have taken,
After Anup Senapati, it is their stand
they
that
had-
they had to do it because of certain orders passed by this court affirmed by.
if some certain orders have been implemented by them, even after Anup Senapati judgment is pronounced, in so far as the order which has been passed by the tribunal in my case, which still stands, why that order will not be implemented? Is there any difference between the order of the High Court or order of the Supreme Court and order of the statutory authority, which is conferred with the power under Section 24B to adjudicate the matters?
We will consider.
But that's it.
Yes.
In my case, my specific prayer is, I have challenged 2009 GIA order. Now, 2009 GIA order, I have challenged on the footing that.
You are not challenging 2004.
Because GIA was released in favor of my client under 2009. So I am not affected by the Anup Senapati judgment, nor it was implemented in my favor. Salary was released in my favor under 2009 GIA order. Therefore, Lordship, Anup Senapati case is not binding to me on the first footing. Second thing, Lordship, 2009 GIA order, I do pray before your Lordship that the law, proper procedure of law was not followed while amending it to the 2009 GIA order. The procedure of law, Lordship, as NV suggests under Section 27.
Procedure of law was not followed in what?
In making 2009 GIA order.
The 2009 GIA order is incorrect.
Incorrect because the authority is incompetent.
The authority were incompetent, but whatever benefit was given to you was under 2009 according to you.
That's what I have challenged, Lordship. That's what I have. 2009. 2009.
No, we have not, speaking for myself, I have not been able to understand this logic that you are challenging the competence of issuance of 2009 order, under which you were given the benefit. According to you, the benefits were extended to you under 2009.
Instead, 1994 GIA order. Instead, I am eligible to receive GIA under 1994. Instead of releasing under 94 GIA order, salary was released in my favor under 2009 GIA order, pursuant to which I filed cases and after cases. When authority rejected by saying that since 94 has been repealed on 2009, therefore you are not eligible to receive this under 1994 GIA order. Let's see, kindly come Section 27 of the Odisha Education Act. Let's. Power to make rules, Lordships. 27. Page 165, my lord, of the book. New book, Lordship, it's only.
Yes.
The state government may, after previous publication, make rules for carrying out all or any of the purpose of this act. In particular, and without prejudice to the generality of the foregoing powers, the state government may make rules to regulate, establish recognition and management of private education institutions in respect of all matters expressly required or allowed by this act to be prescribed. Clause 3, all rules meant under this section shall, as soon as may be after they are made, be laid before the state legislature. This is important. Let's see, the RTI report I have submitted, let's see, that is in P, P,
So what is the effect of rule not being placed before the state legislature?
effect, lordships, the Act 94 GI order was created pursuant to the statement and objection received, and it was passed by the legislature. And on that 94 GI order, the condition of service and under what circumstances, what will be the amount of the salary, everything has been elaborately discussed. And for that purpose, lordship, all the employees, they are getting salaries prior to 2004 under GI order 1994. Now, in this related state 2009 order, which is has got no competency under of the authority, has taken away my right, lordship, by implementing this, by creating two classes of employees on the same footing, lordships. I had joined in the year 1991. Others who have been joined in the during the period 91, 92, 93, 94, they are receiving GIA. Till now, lordship, 2020, after filing counter 2023, 2000, up to 2023, GIA has been released in favor of many. I have annexed those documents, lordship. Therefore, debarring my clients, lordships, who have joined prior to 2004 and during the period of 91, where GI order 94 was in operation, lordships, depriving my right because on the footing 94 GI order specified the salary shall be the employees are eligible to receive GIA within completion of 5 years of service. Now it was further extended in the GI order 94, 3 plus 5 plus 7. The women's college, they are eligible to receive GIA on 3 years, completion of 3 years, and then 5 years, then 7 years. Now, in 2009 GIA block grant order, they say you are only eligible to receive block grant from the date of this act came into force, that is 2009, lordships. Cutting the benefit of continuity of service, lordships. Therefore, lordship, I would like to submit, my lord, the judgment, lordships. The judgment, lordships.
Which judgment? Which judgment?
My first judgment before your lordships is 2023 10 SCC 276, lordship. I'm giving the judgment. 2023 10 SCC 276.
What is there?
It is on the point, lordships.
Why are you getting up the files?
These are judgments. I have made the bunch of judgments. Because the court master said it may not be available. I got the Xerox copy of the judgments and citing, lordship.
On what point you are?
Let's see, on the point that if proper procedure was not followed while enacting that law has to be declared as void.
Which paragraph of 2023? Which paragraph?
Lordship, kindly come to para 114.
So what was under challenge in that provision?
Lordship, in that case, Lordship, CBC Act was under challenge, Lordship.
Their act was under challenge. Here you are challenging the regulation rule.
Regulation rule, Lordship. Here, my focus on the first point, Lordship, it was not laid before the legislature.
Executive policy. That was. The options we have heard. Resolution passing. No statutory.
What my lord asked me, Lordship, my first point is on the putting that, Lordship, it was not laid before the legislature as for the law, Lordship.
Mr. Counsel, have you examined this point?
Lordship, I have examined.
It is an order.
Lordship.
You are questioning.
Mr. Counsel,
Lordship.
We presume that order is ruled within the under section 27. Let us presume that. According to you, that was required to be placed in the house. That was not placed. What is the effect? Have you examined on this point? Do you know what is the effect? Why are you making this submission? You are referring to this. You are challenging the rule, according to you, that is rule under section 27. And you are challenging that on that ground that it was not placed before the house. You have not examined as to what is the effect of the rules not being placed before the house if it is required under the act. And what have you?
Lordship, what I am submitting, once it was not placed before the legislature.
Mr. Counsel, have you done any research on this point?
No.
If you have, then we will do it. We will do it.
Section 28, Lordship.
So you have so far wasted our time. You have given us the bunch of decisions which are of no value. The main ground on which you are challenging the order 2009. So you have not examined that.
Let it come tomorrow.
No, tomorrow. Because we know the answer. Had we not been knowing the answer, we would have adjourned for you to help. But because we know, therefore we will not adjourn.
Let it come any date, Lordship. I'll take only 10 minutes. 10 minutes on that point, Lordship, or other points, Lordship.
Sorry. Other points, say, we are here. We are here.
Let's.
What else? What other points?
Lordship, then Lordship kindly come the saving clause of the Odisha Education Act, which says Lordships, any law for the time being in force and the cases of any inconsistency or repugnancy, the provisions of this act shall prevail. Lordship, on that putting Lordship, 94 GIA order, which was implemented throughout Lordship by giving the benefit to employees who have joined prior to 97 Lordship. Since my client had joined in the year 1991 Lordships, the 2009 block grant order, which has come into force Lordships, that section 7 of that order Lordships that is Lordship 5 clause 6 Lordship, which says Lordship payment of block grant under this order shall be made with effect from February 2009.
So why are you reading section 28? 28 is something else. And you are jumping from 28 to
because Lordship, why I am saying this, by tenure of service is curtailed Lordship here. I have joined in 1991. Now I'll get the benefit in 2009. That is at page 402.
Don't know how to react.
Four 402.
Sorry, sir. Conclude your arguments. Necessary.
Lordship, on the footing, my tenure of service has got no reward, Lordship.
All right, we will see. We are bound by law. We will decide your case. You must have pleaded all these things which you are submitting in your writ petition.
Let's.
We will see. All right. Judgment is out.
But my case is concerned, so keep it.
You have also concluded. Sir. What else?
I have to argue the other points.
Which point?
So far as the judgment of the Supreme Court that Anup Senapati, I'll cite those judgment and I'll address you also.
Then let it be tomorrow. Otherwise, it will become an endless exercise.
No, endless. Keep it.
Tomorrow.
Tomorrow, we have fixed the other cases. Cases of mine also.
We will take up this matter on priority basis because we have heard it. Length. So tomorrow we can. If you have to add anything, you can do it.
Yes, yes. Fixing it at 2 p.m.
Item 77.
May it please my lord, Pinaki Misra here, my lord, appearing on virtually, if your lordships kindly permit me. I'm very grateful, my lord. I'm very grateful to your lordship for having fixed the matter, my lord, with some urgency. My lord, this is, I won't take much time. Automated testing stations, my lord, have been
You are
tendered
appearing
by
in item number 77.
77. That's the one, my lord. Rosemata. It's a company called Rosemata, my lord, Technologies versus State of Odisha.
Yeah.
Now, my lord, this is the Department of Transport in Odisha government, my lord, tendered for what are called automated testing stations, my lord. So there are now these, my lord, state-of-the-art testing stations. And my company, my lord, has done more than 3 lakh all over the country. So I'm one of the premier, my lord, agencies in this. The tender itself said, my lord, that 2 parties will be chosen. So, my lord, once the financial bids and the technical bids are, my lord, open, two parties will finally, it will be apportioned between two parties. My lord, strangely, a pre-qualification, my lord, the clause was put in, which your lordship will find at page 57 of the counter affidavit, if I may show your lordship, of the government, my lord, because they produced very kindly the entire tender document. At page 57, the pre-qualification conditions will not start. So if your lordships kindly have page 57, because that's where it starts. Do your lordship have that, my lord?
Just a minute, 57 of the counter affidavit.
Of the counter, my lord.
Just a minute.
That would be page 284, running page 284.
I'm grateful to my learned friend, my lord.
Yes.
My lord, this is just to show your lordship that the pre-qualification conditions start from here. And clause D there, your lordship will kindly see, the pre-qualification conditions of technical bid and the necessary documents to be submitted along with the technical bid are given in the table below. So, my lord, it's a very exhaustive list. And there, my lord, the internal page 62, if my lords could kindly, my lord, advert to. My lord, I'm sorry, this is remiss of me. I should have had running pages. If the running pages are.
Yes. We are there, Mr. Commissioner.
Your lordship have page 62, my lord, clause 23.
Yes.
A very strange, my lord, clause is put in as a pre-qualification bid. Declaration on non-involvement of legal litigation by bidder or any member of the bidder in case of consortium stroke partnership. And, my lord, this is to be done, as your lordship see, by way of a notarized affidavit, which is, my lord, as per Form S. So that Form S, your lordship will find at page 236 of the internal page 236 of the counter, my lord. And if your lordship just see that, the lordship will see, my lord, it's an extraordinary. Yes, my lord, of the counter affidavit.
Oh, 236, and is that which page?
My lord, it would be.
Just a minute, Mr. Mishra will say.
236 would be page 463.
I'm grateful to my learned friend, my lord,
Page
he's very kind.
463.
Now, this your lordship will kindly see, my lord. I don't think, my lord, your lordship's vast experience both in the bar and the bench, your lordship would never in a tender condition have seen this kind of a pre-qualification clause. It says, my lord, format of undertaking to be furnished on company letterhead with regard to litigation stroke arbitration by sole bidder stroke consortium member to the transport commissioner. We hereby confirm and declare that we so-and-so, my lord, it should be does not or do not, whatever, have any litigation stroke arbitration history with any government department stroke PSU stroke private sector or any other agency for which we have undertaken works services during the last 10 years. So, my lord, unless a company is a virgin company, my lord, which has done no work at all, it is inconceivable, my lord, that this sort of tender condition can ever be a pre-qualification bid. My lord, I straight away ask them, my lord, in there are pre-qualification bid queries. My lord, I straight away ask them, I'm not going to trouble your lordship with the pages. My lord, I ask them, they say, please refer to clause S, that suffices. I send a representation to them saying, what do you exactly mean by this? My lord, they are silent. So, my lord, I come to your lordships, my lord, by way of a writ petition saying this is a completely, my lord, unconscionable clause, my lord, and it is obviously going to keep out an experienced bidder and bring in a totally inexperienced bidder. My lord, so this totally defeats the, my lord, purpose of a competitive bidding. Now, the first round when it came, my lord, on the 11th of March, because the tender was to open, my lord, on the 11th, my lord, Justice B.R. Sarangi's bench, my lord, said that you've made a representation, government should look at your representation, go back to them. So, my lord, I go back to them. And I assume, my lord, that once there's an order of the court, that they will, my lord, look at it with some degree of seriousness. They, my lord, clearly internally tell me nothing can be done. We are going ahead with the tender. So, my lord, I come back with a second writ petition. On the 15th March, my lord, again, Justice Sarangi's bench, my lord, gives a direction that the representation should be looked at. My lord, they don't do it. On the 18th, 16th is the bidding. The 16th, my lord, was the bidding last date, my lord. So, my lord, on the 18th, my lord, they send me a disqualification letter saying you are disqualified but not on this ground. And I'll show your lordship the very well, Lord, strange now reason, because they obviously, my lord, by then realized that this is going to be untenable and, my lord, you can't possibly, my lord, justify this in court. So therefore, if your lordship just kindly see the averment at the counter, and, my lord, I say with respect, this ground alone, my lord, ought to have this tender cancelled, because, my lord, today we are under model code of conduct. So till the 4th of June, nothing can be done in any case. No tender can be given. So far, only, my lord, the technical bids have been opened, financial bids have not been opened. What this does is, there are 7 or 8, my lord, important players in the country. 3 bid, including me. I have been disqualified. So, my lord, for 2 bidders, who are the only 2 bidders, obviously, my lord, who the government wants to, and with great respect, I say this, my lord, advisedly. The government has obviously pre-selected 2 bidders, my lord, and I'll show your lordship how they've got internal information, which is why they put the bid in a particular way. So 2 bidders to be given, shared between them, everybody else is out. So I say with great respect, my lord, this is one of those classic cases where your lordship, in your lordship's wisdom, will cancel this, my lord, tender and say, you, my lord, weed out this completely unconscionable clause and come up with a fresh tender. Because, my lord, kindly just see this. What does the counter now say, my lord? And this is extraordinary that somebody, my lord, should, after a pre-qualification bid like clause like this, the counter at page 25, internal page 25, para 20, kindly see what how they explain this in their counter. And, my lord, this alone, my lord, to my mind, my lord, disentitles the government to any sort of, my lord, sympathy from your lordships. May I read that, my lord, to your lordships?
Just
para 20.
Just a
Para 20 at page 25.
Just,
Your lordships have that, my lord?
just a minute.
Running page 252.
No, we will.
Running page 252, I'm grateful to my friend again, my lord.
Yes, paragraph 19.
My para 20, my lord.
Para 20.
My lord, that the averments made in paragraphs 4 and 5 of the writ petition is denied. The condition to submit declaration of no litigation pending history of litigations as provided under clause 23 to be submitted in form S. My lord, kindly mark with great respect, my lord, is no way disqualify a bidder for evaluation of his technical bid. Nowhere in the tender condition it has been stipulated that the pendency of litigation against a bidder is a disqualification for evaluation of his bid. Section 9 of the RFB provides, my lord, criteria for evaluation of technical bid and price bid. The said evaluation criteria has no nexus with the litigation history. I say this with great respect. This is completely untenable and, on the face of it, against what is a pre-qualification. What is the meaning of a pre-qualification clause? Which means, my lord, if you don't satisfy that clause, you are not competent to bid. And this is repeated again, my lord. If your lordship kindly find, little later on, my lord, 3 pages down at para 33, that they humbly submitted that clause 23, my lord, of part 1 cannot be said to be a disqualification for evaluation of the technical bid. But however, it is a tender condition which the bidder is required to submit a declaration stating all pending litigation for the last 10 years. Now, my lord, just see how dishonest is this. No, Form S says, I kindly see what Form S says, my lord. Form which I just read out to your lordship.
Form F may be only a kind of declaration, but let us again see the qualification.
Form S, I'm sorry, that is the affidavit I have to give. Form S is the affidavit form, and it categorically says we hereby confirm and declare that we do not have any litigation or arbitration history with any government department, PSU, private sector. This is the form I have to fill. So if I have a litigation, how can they say this?
No, if you have the litigation, and because of that you are disqualified because of any provision in the bid notice, then the matter will be different. Where is that disqualification clause?
No, Lord, I am not. My problem is, I'll tell your lordship what. Unless this Form S, these are now, these tenders, as your lordships are aware, these are all, now automated tenders that go under, what is known as a e-Nivida portal. Because none of them, are now physically given. So in this e-Nivida portal, I have to file this
Otherwise,
How
it
do
will
you,
not accept it.
Mr. Mishra, how do you submit that if you make a declaration that a litigation is pending, you shall stand disqualified?
On the contrary, my lord, it is in the inverse. The declaration I have to give is that I do not have any. I do not have any.
Therefore, you give this declaration that you don't have. If you,
But I do have. I do have. My problem is I do have. So therefore, my lord, if I do have, I have, my lord, several arbitrations going on with several departments, my lord. So because I do have several arbitrations going on with several departments, because I have done 3 lakh.
but that declaration is mandatory.
That's right. That's the problem. Without it, my tender will not go through.
He could not participate.
That's right. I'm technically disqualified, my lord. With great respect, the inference clearly is that if there is any litigation or pending, then you are disqualified. That's it. That is the government's, either somebody there is complete non-application of mind in putting in this condition. Because if this is what they say in their affidavit, the affidavit is at variance clearly, with this clause, with this Form S.
And what is this annexure for, Mr. Mishra?
My lord, if you
Page
don't mind,
46 of your writ petition.
Page 46 of my writ, my lord.
Rejections then.
Now,
rejection.
This is a communication dated 29
this is, my lord, the 18th March, my rejection, that my tender has been rejected. But my tender, my lord, this is the 1-page rejection letter I got. The counter affidavit now gives, my lord, the details for the rejection. So the detail for the rejection, my lord, is not that this offending clause, my lord, has been held against me. Now that I'll show your lordship again. That is something, my lord, where your lordships, my lord, now in at least 3 judgments, I'll show your lordship. A minor ministerial omission, my lord, because of that, they have chosen to disqualify me, and it is entirely again their own fault because of the manner in which this tender is couched. I'll show that to your lordship. This
So
is
what
just
are the reasons? What are the reasons assigned?
So may I take your lordship to the counter, my lord, again? 272. My lord, page 272. Again, my lord, if my learned friend Mr. Misra would be kind enough to tell your lordship, it's annexure J3. Annexure J for Jack 3, my lord. My lord, there were three conditions.
499. Last.
Annexure J3, my lord. Now, my lord, kindly see, there were 3 conditions, my lord, financial conditions I had to meet for this tender. One is, my lord, and I don't need to, my lord, take your lordship to those pages because they are met. One is at page 54 of the counter affidavit that I have to put in an 80 lakhs, my lord, EMD, an earnest money deposit bank guarantee, to show that my financial worthiness is there. That I have done. Number 2, my lord, is very strangely, there are 2 sets of fees, my lord, that they have wanted. One is an online fees for tender processing fee it's called a TPF, a tender processing fee of 2,950 rupees. That's all. That I have put in. Then, my lord, your lordship will find at this annexure J3, this is the reason now given for my disqualification, that there is a 10,000 rupee further bid processing fee. I don't know, my lord, how they have. First, there is an online tender processing fee, and there is an additional bid processing fee. This bid processing fee of 10,000 rupees had to be also, my lord, included a GST component in it. They don't mention what is the GST component. My lord, everybody is sort of wondering what the GST component is. What they do is they quietly tell this bidder number 2 and 3 at J3 that you have to put in 1,800 rupees. So, my lord, they happily put in 11,800. I put in 10,000. and they say you are disqualified because you are 1800 rupees short on your GST. The next day, my lord, when I find out that this is the trick that's been played, I immediately, my lord, go and deposit. Now, very interestingly, my lord, this is obviously not a disqualification, my lord, criteria, because your lordship will find, my lord, if your lordship just kindly see page 192 of the counter. Very interesting, my lord. Page 190. I'm sorry.
Writ petition, sir.
I'm sorry, my lord. I'm sorry, my lord. I'm taking your lordship to the writ petition.
Yeah,
I'm
no,
very
no,
sorry.
no problem.
Page 192 of the writ petition, if your lordship don't mind, my lord. I'm so sorry. Your lordship will see that on the online portal doesn't consider this in any infirmity, because if your lordship tell me, I will, my lord, then point out the reason at page 192, if your lordship have that.
Yes.
May I, my lord?
192 of the counter affidavit.
Of the writ petition. The writ petition.
The
writ
petition.
The writ petition.
21. Annexure 21.
It is, my lord. I'm grateful, my lord. I'm so grateful.
Yes.
This is, your lordship will see on the top. Welcome to the e-procurement portal of the government of Odisha. So this is that Nivida, my lord, e-Nivida portal. This e-Nivida portal, kindly see, my lord, 10,000 rupees on top, it says success. So therefore, it has accepted my 10,000 rupees. Then, my lord, the 2,950 rupees in the middle, success. It has accepted it. The 80 lakh bid bond, it has accepted success. So, my lord, clearly, therefore, my bid has gone through as far as the validity is concerned on e-Nivida portal. Otherwise, my lord, if I had to put in 11,800, it would have rejected it at 10,000. In any case, my lord, your lordships are aware GST 1800, my lord, is something which is to be paid to the government, my lord, at the end of every month. So therefore, there can be no fatal, my lord, infirmity in my not having put in because I gave the GST amount immediately thereafter, and they've accepted that also. That GST amount is now with the government. Next page. It's on the next page. Your lordship will see at page 193, just the next page, my lord, which is annexure 22. Your lordship will find, as soon as I realized that, you know, some little subterfuge had been played on me, you know, I immediately went and I'm sorry, I've lost your lordship.
Yes,
Lord,
it
I
is
don't
there.
know. Yes, my lord, I lost your lordships on the screen. I don't know why, my lord. Are you?
Yes,
do you
yes,
have my notes?
we are hearing you.
I'm so grateful. I'm so grateful. I've got your lordships back on the screen, my lord. So, my lord, your lordship will kindly see here the 1800 rupees immediately on the next day, on the 19th of March. I have, my lord, deposited that also, the GST amount also. But now, because it was 11,800, instead of that, I put in 10,000. My lord, other than 80 lakh bid bond, you've got everything. I am one of the, my lord, 3 lakh stations I've done in the country. But may I just show your lordship just a couple of judgments? I'm carrying coal to Newcastle, my lord. I know your lordships are far too, my lord, adept at this, my lord. But the two judgments, in fact, of the Orissa High Court, one of the Delhi High Court, where, my lord, your lordships have clearly held. My lord, 2 hours of justice, in fact, Chief Justice Vineet Saran's time, my lord, in the Orissa High Court, where his lordship has said, my lord, if I may, my lord, we have a colleague there who will hand over the judgments to your lordship.
Please. Please give us the decisions.
You're referring to which one?
Please give all three. Please kindly give all three. Nestor Pharmaceuticals. Nestor Pharmaceuticals.
Yes, yes.
And Kaustuva Sahu, which are the two Orissa High Court.
Essential and non-essential condition.
That's right. It's not your lordship. I'm carrying total Newcastle. I know, my lord. Just, you know, that you cannot, you know, disqualify me for something which is so ministerial and so minor. You know, may I just show your lordship first the Nestor Pharmaceuticals, which is Chief Justice Saran sitting with Justice K.R. Mahapatra, judgment of your lordship's court, my lord. Page para 20. Public money is involved. A PSU, in view of the principles of good corporate governance, may accept such tenders which are economically beneficial. It may be true that essential terms of contract were required to be fulfilled. If a party failed and or neglected to comply with the requisite conditions which were essential for consideration of its case, it cannot supply the details at a later stage or quote a lower rate upon ascertaining, you know, the rate quoted by others. So, you know, that is trite. There's no question. My lord, another order, my lord, another judgment of Justice Saran again, my lord, like para 9, which is this Kaustuva Sahu, where his lordship, I'm just, my lord, reading it out, I don't need to trouble your lordship. Where his lordship says, my lord, in the given circumstances, considering the fact it's admitted that all the papers had actually been submitted before the appropriate authority. As such, the mistake which occurred in the affidavit was by inadvertence and did not materially affect the case or adversely affect the interest of any of the parties. And thus the same ought to have been condoned and rejected on the tender on this ground is, my lord, unjustified. My lord, that, and there is a Delhi High Court judgment again of my lord, Justice Vipin Sanghi and Chief Justice Sanghi and
What judgment, sir? Which judgment you are referring to, that second one?
Prativa Sahu, some Sahu.
Kaustuva Sahu, please, and Nestor Pharmaceuticals, please. Those are the two judgments of my lord Chief Justice Vineet Saran as he then was, my lord.
I don't have that right.
And
All right.
there's one of the Delhi High Court as well. But my lord, the Supreme Court order is the judgment in BS and Joshi is the main one, my lord. And then, my lord, the other thing, government must be, my lord, fair, and that's why the Delhi High Court, my lord, the lordship say, in our view, the respondents have resorted to hair splitting. The approach of the respondents cannot be described as either fair or reasonable. The respondent cannot sit with a magnifying glass while examining a bid document with the objective of disqualifying bidders on some or the other ground. So, my lord, this is, I say with the greatest respect, my lord, clearly they found out that there was a huge mistake in bringing in that kind of clause, that it would not sustain, my lord, any kind of scrutiny of a court. So they have now, by way of affidavit, sought to give a totally different color. And it's untenable. What they are saying, my lord, on the face of it, the explanation does not fly, number one. Number two, my lord, now to disqualify me, they, my lord, say this pittance of 1,800 rupees GST, my lord, which doesn't have to, my lord, go to the government's pocket. It has to go to it doesn't have to go to the transport department's pocket. It has to go, it has nothing to do with either my financial capability or my technical capability. So, my lord, I leave it to your lordship's wisdom. If your lordships, my lord, want to, my lord, set aside this impugned order and say the ministerial omission is not enough, consider them, then, my lord, the problem is we will only be 3 bidders and two of them, my lord. Now, today the position is the third bidder is out, so there are really 2 bidders for 2 positions. So that in any case, your lordship always frown upon. But then there'll be 3 for 2. My problem, my lord, sometimes is somebody will come to court, I have no doubt tomorrow, my lord, to say that if this clause has been now struck down by your lordship, which is, my lord, an untenable clause, then I too would have participated. I couldn't get to participate. So therefore, there should be a fresh tender. So it's a very piquant situation, and the government has only invited itself, trouble for itself, by, my lord, resorting to this. I'm very grateful to my lord, my lord, for a very patient hearing. Very grateful.
Thank you. Thank you, Mr.
Can I just indicate one thing, actually? Mr. Mishra, can I just indicate, supplement
Of
one
course, of course, please. It's absolutely my pleasure. Subject to my lord's, of course, permission.
We will see. We will see, Mr.
I'll just supplement one thing, madam.
We will take up the matter tomorrow
Right.
for the reason that some cases are being going to be taken. Rather, they are fixed. They are fixed for 4.
Oh.
All right. So we will take up the matter tomorrow, Mr. Mishra. You are not required to be there.
Very good. Well, any time that your lordships are kind enough to consider
2 p.m.
2. I'm so grateful. Deeply grateful to my lord. Deeply grateful.
Specialist.
Contempt. All contempt. Thank you. Who is appearing for the estate in that case?
Lord, I am appearing for the tendering authority.
Tendering authority. And who are for
One
private?
of the technical bidders who has been selected.
Tomorrow.
Specialist fresh admission, OCRMC 591 of 1999.
No instruction.
Complied with?
No instruction.
Oh, no, but the order has been complied with, no? Yeah. May kindly be disposed of. Oh, no issue.
Old matter, 19.
The petitioner does not have any instruction to pursue this matter. This application stands disposed of accordingly. It appears that it is an old matter of 1999, and in the meanwhile, the petitioner has lost interest in the matter. Yes.
Item number 2.
Item number 2, the brief has already been transferred.
Yes.
Name of Mr. Rafael Associate Mayor deleted.
This contempt application of 2009. Learned counsel, Mr. What is your name?
Amit Kumar Das. On behalf
Sir,
of
Amit
Mr.
Kumar Das. Learned counsel states that the counsel for the petitioners do not have any instructions in the matter. So stop. This application is accordingly dismissed as not pressed.
Item number 3.
Complied.
The order complied with that.
Item 4.
Item number 4, my lord, undated 31st/10/1997, this honorable court passed a interim order to stay up and in the meantime, my lord, my lord, 17/11/2014, the stay is there, but subsequently, my lord, the opposite party demolishes my house, my lord. That's why I filed a contempt petition before this honorable court, my lord.
No, but what happened to the main OJC number 1509?
It's pending, my lord.
No, I think
7 is pending.
5/4/2017, it has been dismissed for non-prosecution.
That has been dismissed.
5/4/2017.
Oh, no.
OJC 15090, my lord.
That's been dismissed.
Yes.
That has been dismissed.
5/4/2017, I think, if I'm not mistaken.
In contempt application arises out of an interim order passed in OJC 15090 of 1997.
Yes, ma'am. I had sent a copy to Mr. Shashi Babu in the.
High Court of Oh, stop. The said OJC number 15090 of 1997 has been dismissed for default by an order dated High Court 2017. Oh, stop. This application stands disposed of accordingly. Yes.
Item number 5.
No representation, dismissed.
Item number 6.
There is no representation on behalf of the petitioner as a government. This contempt application is accordingly dismissed as not pressed.
Item 6.
Yes, same order.
Item number 7.
Same order.
No instruction, my
Item number 7.
My lord.
Learned counsel for the petitioner states that he does not have any instruction to press this application. So this application is accordingly dismissed as not pressed.
Item number 8.
8, your lordship, may kindly see my contempt application that was arised from the interim order passed by this honorable court by order dated 4/5/2011. My lord, the writ petition is still pending, my lord. And on this contempt, my lord, the order passed by this honorable court was for the stay of the impugned order in the writ petition. After this, my lord, they have violated the order of the interim order and they have demolished my entire structure, my lord. After this, I have come before this court in the contempt petition, and this honorable court has directed them for the personal appearance. Personal appearance was there for all the contemners, my lord. And after that, my lord, this honorable court has directed for an inquiry by the deputy registrar, learned deputy registrar, inquiry and investigation. My lord, may kindly fix this to after 2 weeks in the main list if it is possible, my lord.
List this matter on.
My lord.
After the holidays.
My lord.
Item 9. Item 9.
No one appears.
Item number 10.
Complied with.
No, my lord, it's not complied. What I'm saying, SOCOS has been filed earlier, my lord. So actually the writ petition 3516 is supposed to be the contempt arises out of 3516. That is not on record, my lord. 3516 is the writ petition. That is not on record. 3516, 2014.
That is disposed of.
But
Disposed
this
of
is
the contempt.
2011. 2011 contempt.
No. Contempt is 2014, my lord.
9, 10.
It arises out of 3516 of 2014 writ petition number. That is not on record, my lord. Maybe.
Compliance affidavit has been filed.
The earlier affidavit they have filed, my lord. Then thereafter there has been an order for personal appearance. They have appeared in person, my lord. It was dispensed with, but it was not complied. The order was not complied. Then thereafter kindly see the order dated.
The compliance affidavit is another case they have given.
No, same case. Kindly see order number 5, 27 to
All right, we will
2015.
take up later. Those. Are you sure that the order has been complied with?
Yes, Mr. I've given the affidavit also, Mr. In 23, I've given the detailed affidavit how the order has been complied with.
The affidavit they have filed recently, my lord, that is, he was not the contemner. The contemner has filed one affidavit earlier, my lord. Then thereafter, he has asked for the personal appearance. The personal appearance on that very day, 27th of February, there has been ordered to file a reply to the lasses. That is, may I placing the order, my lord? Kindly see, just one line. 27 to 2015, my lord. Yes, 27 to 2015. The last para.
Where is the order?
Order dated 27 to 2015. Passed in contempt number 1289 of 2014.
Which annexure?
No, but the order sheet I am placing, my lord. The order passed in contempt to 1289 2014, my lord. This contempt.
Yes, which date?
27 to 2015, my lord. The last para, my lord. A memo is filed today in court on behalf of the petitioner in the connected writ petition. So and so, copy of which is served on the learned advocate general in court today. The petitioner is at liberty to make application for issue of transit permit pursuant to a direction dated 25 to 2015, passed in the aforesaid writ petition for removal of the materials from the existing site to the relocated site as may be necessary. The director mines is directed to file his reply within a period of 2 weeks from today to allegation made by the petitioner that in spite of the application made by the petitioner on 22nd 1, 2015, the updation of the website for acceptance of the application of the petitioner was made only on 22nd 2, 2015, that too partially. And why appropriate direction as may be necessary shall not be passed against him in the present contempt proceeding for delay caused for issuance of transit permit in spite of our earlier direction. So thereafter, they have not filed this reply. They have not.
Thereafter, I've given the details. He submitted the bank guarantee, and that was accepted. And he has been allowed to lift all the materials there, Milos. That is my affidavit.
When did you file?
Milos, I filed it on Milos.
The director is supposed to file.
25/8/2023, Milos.
The director is supposed to file, my lord. The current deputy director has filed one affidavit saying not saying this. He has to explain all the why appropriate direct of application made by the petitioner on 22nd for acceptance of the application was allowed on 26 2015. That means 31 days. It is valid. They have not given any relief. They have not accepted my.
What about your writ petition that is pending or it was disposed of?
That contempt arises has been disposed of. Contempt arising out of the writ petition that has been disposed of. 9/5/2014.
You want him to be punished only?
No, I have incurred, my lord, 1,33,00,000 I have incurred. It's not once or twice, my lord. It's a repeated, deliberate negligence. I can show from the record itself. I have filed a reply to that effect.
We'll hear it.
Yes.
I think the connected rate has become infructuous. That can be disposed of. Today it's listed. just below that. I'm for the Paradip port.
The connected
I
date
think
has.
that can be
the
what my friend says. That has become infructuous. It was for lifting of a cargo from a particular plot. It was almost 10 years back. So I think that has become
that
24057.
my lords.
Yes.
24057 can be disposed of. I think.
24057 can be this.
WJC number, sorry, WP number, application. Then counsel for the parties that this application has become infructuous and stands disposed of accordingly. Contempt matter will come. Chief Justice.
Specialist fresh admission item number 1.
On behalf of Mr. T.K. Kamala, I may kindly be permitted to submit, my lords. Here, my lords, this order, my instruction is the order has not yet been complied with. These all are workers, my lord, and workers of a Sarala spinning mill, and the matter carried to Honorable Supreme Court, my lords. And the item number 6, all identical, my lords, 1, 3, 4, 5, and 6. So all are identical. State has not filed compliance
No,
affidavit.
in item 6, we have filed in compliance. We have
That
filed
copy
an
just
affidavit.
now I have served. I have received just the copy just now. Your lordship may kindly call this matter some other day. I have given also another 4 left out, my lords. And let state file also compliance in so far earlier matters 1, 2, and 3.
Because this compliance that we have filed in item 6, my lord, it actually should cover all the contenders, my lord.
So let me see the order.
Yes, let's see. Item 6, let's see.
No, any order.
Yes, item
All the-
6,
all
let's
the-
see. Yes.
All the 6 matters arise out of same order.
Yes, yes. Your lordship may kindly turn to flag C, item number 6. I have given
No,
chronological.
forget C. Where is the order?
Order, yes. Order is page 14 in item 6, my lord.
Yes, what is the order?
Order, my lords, the relevant page is page 7. Order dated 26/3/2009, lords. Permit to place, lords. Paragraph
So
4.
whether the order, whether they have disposed of your representation.
But that the after this, my lord, in
That was the only order.
yes, so
So
far
is
as
there
the
no-
yes, my lord, so far as the number mentioned, my lord, the writ petition number mentioned, that she has received all her benefits, my lord, and that was the order passed referring that order.
See, there is nothing in the order except for disposal of your representation.
Yes.
That has been done.
Yes.
No contempt is made out. We will give you liberty. The court will
Yes.
give you liberty to question.
Yes.
All right. The 1 to 6. It does not appear to be in dispute that in compliance of the order dated 24/3, same order,
Same.
24/3/2009, violation of which has been alleged in the present contempt application, comma, a representation of the petitioner has been disposed of. So, in my opinion, the no case is made out of deliberate disobedience of this court's order. The contempt proceeding stands dropped accordingly. 1 to 6. Item number 1 to 6. 1, 2,
No, let's
3,
take
1, 3, 4, 5, 6. 1, 3, 4, 5,
Yes.
6.
With liberty, let's kind.
The petitioner shall have the liberty to question the correctness of the order passed on the representation before appropriate forum in accordance with it.
Grateful, let's. Item number 2.
The order passed by this order dated 5/1/2005 to 2015 has not been complied with here, my lord. The petitioner, who is a senior lecturer, was dismissed from his services and thereafter he had filed.
Where is the order?
Yes, ma'am. The order is that page 9, it is annexure 1.
Annexure 1, there is a long order, but the last portion of the order, your lordship have a glance to page 27. 27 is the ordering portion for the
You have not been reinstated.
No, in the meantime, I have retired.
Then
Retired here. Thereafter, my lord, they have said that I am entitled to get all the consequential benefit. Lordship have a glance to page 27.
yes, we are there.
My lord. So, my lord, I am entitled to get all the benefits, and they have, without complying the order, at that time, my lord, I was not retired, but they have filed a writ appeal. Writ appeal has been disposed upon in the month of September 2021. By that time, I have retired, and in the meantime, they are liable to comply the order.
What happened in the writ appeal?
Writ appeal has been dismissed, filed by the university.
All right.
So I am entitled to get all the benefit as per
Yes,
the.
have you given?
Some benefit has been given, ma'am, but however, I will seek the compliance.
All right, we am posting this matter after vacation. And if it is not done, then the court will punish you. And it is submitted by learned counsel for the petitioner that this court's order, disobedience of which has been alleged in the present contempt application, has not been fully complied with. Learned counsel representing the contemners does not submits that that the court's order has been partly complied with. So stop. List this matter on after vacation. So stop. It is made clear that if in the meanwhile the order is not fully complied with, the court shall consider initiation of contempt proceeding against the contemners. Yes.
Item 7.
Kindly fix a date so that. Oh, sorry, sir.
Date will be there.
My lord.
Item number 7.
No instruction. No instruction.
Item number 8. Item number 8.
Item number 8, where?
No, sorry.
Item number 8, no one appears.
Item 9.
Order that is 17/11/2014.
9.
Yes.
Yes.
Item number 9. That
Yes.
is passed in position number 2393 of 2001.
Yes.
That's regarding the release of the balance amount, sanctioned balance of the sanctioned amount.
Whether the order has been complied with or not.
Order has been complied in the meantime, and they have taken, I have paid the entire loan amount.
Only by the NOC has not been paid.
Yes.
I will give it by tomorrow or any day. Let him approach the office and we'll hand over the NOC.
When we have repaid the money, let them issue the NOC only, nothing else.
Yes.
If the order has been complied.
Yes,
with,
yes.
Yes, the order has
it
been
is
complied.
admitted at the bar that this court's order, violation of which has been alleged in the contempt application, has been complied with. Of the contempt proceeding stands stopped accordingly. Yes.
Item number 10.
Record our name.
Item 10.
Yes.
Lord, in this case, my lord, although they have filed the compliance affidavit, they have not complied fully, my lord.
Let us see the order.
Your lordship may can see in view, page 9. In view of the aforesaid submission and position of law, this court directed the opposite parties to pay the time-bound advancement scale of pay to the petitioner with effect from 2/7/1988. That is the date he has completed 15 years of service. The area amount of time-bound
I filed the
advancement
compliance
scale of pay.
affidavit. I've given the details, the amount also which has been paid to him. Lords. I filed the affidavit only on 11th of March 2024, where I paid the amount. Lords.
Everything has been paid.
My lord, no, my lord, TBA, that is, they have paid only two TBA. And the third ACP, they have not paid. I have already retired, my lord.
Where is the direction to pay third ACP?
Third,
Whatever.
if they will continue to pay, then I will get
Where
the
is
third
the
ACP.
direction?
My lord.
Is there any direction by the court? And the court's direction is to be seen.
My lord, liberty should be given to, so that I can.
And counsel appearing on behalf of the petitioner has not been able to dispute that this court's order dated 4/3/2011.
My lord.
passed in WPC number 5131 of 2011 has been complied with. Post office has however submitted that the petitioner has not been allowed
third ICP.
third SCP consequent upon the grant of benefits in terms of, in the light of this court's order dated 4/3/2000. Stop. In the court's opinion, no case of deliberate disobedience of this court's order is made out. So stop. The present contempt proceeding is accordingly dropped. So stop. It goes without saying that the petitioner shall be at liberty to pursue his remedy before appropriate forum in accordance with law in relation to the entitlements, in relation to his other entitlements.
My lord, third ICP.
Third SCP.
Obliged. Secondly, sub item is also same.
Same, no. So I have filed the compliance affidavit to have compliance.
Same.